May be pleases your lordship. Beg to mention item number 3738 of supplements, your lordship. Here, your lordship, we have, we will going to file our affidavit today in due course, already sent it for vetting. Today we will receive it. So we'll filing it in due course, your lordship. Kindly madam, me list after one.
Item number
3738. We have taken consent as well.
Lordship, date may be fixed as per
Date
direction.
fixed After 1 week.
On on 9/1, Lordship directed to consider the interim prayer today, Lordship.
Lordship, next week, your lordship, in today, your lordship, we are going to file it.
okay. Let it be on Monday.
Yes, your lordship.
Monday. Ms. P. Das, Learned Standing Counsel for the respondent in Secondary Education Department.
Wednesday.
With consent from the other side, press for
Here it
listing
is.
the matter on Monday,
Wednesday, your lordship. Wednesday.
Wednesday,
Ah.
as the affidavit in opposition is
9, 10,
to be filed during the course of the day. Fair allowed,
9 to
this list the matter on Wednesday. Yes,
oblige.
I'm deeply obliged. May I please your lordship? Lordship, with the consent of the petitioner, I beg to mention item number 4, lordship. Lordship, I am appearing for respondent number 3 and 4 in this matter, lordship. The affidavit in opposition has already been prepared, lordship. However, due to non-availability of any document in the Guwahati office, we could not file it today, your lordship.
Mr.
We-
Your name, please.
S. Paul, on behalf of A. Bhattacharya.
Mr. S. Paul, Learned Counsel, appearing on behalf of Mr. A. Bhattacharya. Learned Conducting Counsel for the respondent number 3 and 4 submits that the affidavit in opposition has already been prepared and will be filing within a period of 1 week from today.
1 week.
And he press and with consent from the other side, he press for listing the matter after a week. They are allowed. Rest shall list the matter after a week.
What obliged?
May it please your lordship, in item number 13, your lordship, we have filed our reply. That is not on record, your lordship. It may be called for.
Okay.
Oblige, your lordship.
Mr. Lordship, I beg to mention item number 33, Lordship. Consent of the other side, Lordship. We are going to file our affidavit with the Lordship. Only the matter
Item number
33.
(33).
Lordship.
Ms. Kempre, Learned Counsel for the respondent number 1 and 2.
Yes, whenever one is
With consent from the other side, press for listing the matter after.
Next week, Lordship, I have got a petition order.
Okay. Next week. Fair allowed. Rest shall list the matter after a week.
May I please, your lordship, I beg to mention item number 40, lordship.
40?
Yes, sir. Lordship, this is the connected similar matter, lordship. It is the similar matter is listed in different court, lordship, today. So since it is a tag matter, lordship, the matter may be listed along with the another matter.
Item number 40,
Yes, lordship, supplementary list.
along with item number,
It's-
along with
it's listed
WPC
in
number.
WPC number 5985 of
59?
2025.
Uh, Are they two possible? Next day. What is the number of that petition?
WPC number 5985 of 2025.
5985 of 2025. Your name, please?
L. Wangsa, your lordship.
Learned Counsel for the petitioner submits that connected matter being WPC number 5985 of 2025 is listed before the court number 6
See.
today,
Yes, lordship.
and see price for listing this matter along with the WPC number 5985 of 2025. Register shall do the needful and list the matter before the appropriate bench on next date.
Obliged.
In item number 6, my lord, we filed an affidavit for I, my lord. That may be called for, my lord.
Item
Today
number
it was
6.
filed, my lord.
Kavit?
Orders for no steps.
Lordship, I will take a, today I will serve the copy. I beg to mention, your lordship, in two cases, there is a two case connected, your lordship. Read petition 7049 may be also be analogous. Same matter may be tagged with this petition here.
What is the number of that case?
WPC number 7049, 2025. Sri Sandan Dinga versus Union of India. Same matter, your lordship.
7049.
2025. In that matter, this honorable court has directed to take instruction to him, and I had already served the copy. Anyhow, since I have not placed my service copy on today on record, so I have served a copy. My humble submission is to let the matter may be record with both the cases with a fixed date, your lordship.
Okay. Heard Mr. B.N. Gogoi, learned counsel for the petitioner. Mr. Gupta for the respondent number. Learned CGC for the respondent number 1234.
Yes, my lord.
1234.
What do you have?
And you have taken a step for service of notice upon respondent number 5.
Lordship, I will take steps.
You have taken a step.
I will take steps.
Okay.
Within day.
Mr. Gogoi, learned counsel for the petitioner submits that during the course of the day, he will take step upon the respondent number 5. Respondent number 5. Mr. Gogoi further submits that another matter being WPC number 7049 of 2025 is pending before this court. And this matter may be tagged with the aforesaid matter being WPC number 7049 of 2025. SSL list this matter along with WPC number 7049 of 2025 after a week.
Lordship,
After a week.
I am deeply obliged.
Item for admission, item number 2.
Affidavit.
Yeah,
Oh, number 2.
fine, good.
Good, sir.
Yes, they have filed the affidavit, your lordship, affidavit in reply.
Furnish me the copy. Since I heard that they not filed.
Sign
They have
over.
not furnished copy.
Sign over.
Okay. Okay, after some time, let the council come.
At 2, lordship.
Time being not at all. Only time being.
Yes, sir.
Item number 3.
Yes, sir. Mr. Brady.
Mr. P. Doctor is some lodges, some day.
Okay.
Item number 5.
May it pleases the lordship. Kindly pass over for the time being, lordship. My senior is on the way.
Who is your senior?
Miss S. Ali, your lordship.
Yes, sir. Okay, after some time.
Number 6 and 7.
Lordship, may kindly peruse the last order. I was directed to take steps, instruction, whether we have received the amount from IIT Guwahati and whether we have disbursed it. So I have received the instruction today, yesterday, my lord, that we have received the amount from IIT and we have deposited in respective executing courts. But the next date of this particular case, the execution case in respect of which this writ petition is pending, that is fixed on 22/2. So I pray that Lordship may kindly fix the matter in the first week of March Till then, I will bring on record the exact status of that case and also bring on record this piece of document regarding the payment on from our part.
I agree to what my friend says, Lordship. What has happened here is there was a dispute as to who would be paying the amount. The way it would be the central government, the IIT, or the state government. Now finally, on the orders of this honorable court, a meeting was held between the secretary and the chief secretary level officer of the state. And pursuant to that, whatever amount was determined in that meeting by the state and central authorities, that has been released by the central government to the IIT, and IIT has released it to the deputy commissioner.
District Commissioner.
Who picks my
So, perhaps the issue of payment is no longer there. So far as the central government and the IIT is sublost.
page number 2?
So this affidavit has not yet been filed. It is not on the record.
My extra copy my lord have given to my lord.
Maybe, but our record,
Record has not come my lord.
no, not only record. System has not shown that you have filed the affidavit.
My lord.
Lordship, pass appropriate orders on the next day. This will also come on board by.
Yes.
Okay. Mr. Bhattacharya, learned counsel for the, you were for the petitioner?
Petition.
My lord,
Petitioner.
Lordship, may I please, my lord? Lord, I am for the petitioner of the item number 7, my lord. I have some different issue, my lord. In my case, my lord, money already been laying in that with the deputy commissioner, my lord. However, my lord, the status is that, my lord, when the petitioner went to the office of the deputy commissioner, my lord, there is some difficulties is that, my lord, the petitioners earlier approached this honorable court by way of a writ petition, my lord. There is a direction, my lord. But what happened, my lord, as per this affidavit, my lord, filed by the government, my lord, the writ petition number mentioned is the earlier writ petition, my lord. The writ petition, present writ petition number not been mentioned, my lord. Lordship may comes once may affidavit by the department, my lord. It is affidavit dated 28/1/2025. 28/10/2025, my lord. Last page, my lord. Lordship may come to 206 page,
Okay.
page number 206.
Executing order. এখানে আমার first week of March হিসেবে।
My lord, in item number 7, there is an execution code. In my case, there is no execution code, my lord. That is, my lord, that is the difference, my lord. My money presently lying in the bank, my lord. That, my lord, this petitioner, the amount may be released to this petitioners, my lord. Only that much, my lord.
Amount is already earmarked for him.
Then release it.
Yes,
My lord, the amount.
that is already
to-
deposited in the state bank. Let
30
him approach
30
the deputy commissioner, he will do the needful. Man.
These observation may made, my lord, to these petitioners, my lord.
No, whether you have approached the deputy commissioner.
Yes, my lord. Verbally, he approached, the petitioners approached the deputy commissioner in between, my lord. They asked that, as my lord, there is no execution code. They were a little bit confused how the money will be disbursed to the petitioners, my lord. So, my lord, that observation may made, my lord. The present petitioners may disburse this amount, my lord. Only that's observation.
Okay.
Actually, my lord, earlier,
So we are disposing of item number 7 with
My lord.
the aforesaid
My lord.
direction and observation.
my lord.
And in respect of item number 6, we will list the matter after a week.
No, my lord,
No,
this-
it will be-
This item may be kept pending, my lord.
It may be taken up on 6th of March.
Both the matter.
Yes,
My lord.
till then we will do the needful. Man.
Okay.
Only, my lord, these observation may make.
Item number 6, should kindly see the last order. There is observation regarding it's payment of the money to deposit to the court. It may be observed in this.
No, we have already deposited. Within the, before the executing court.
That is their instruction, here referencing and representing 405. Personal execution proceeding will have been fixed on 30 and this one. So if they have deposited 8, that is the yesterday's information instruction. If they have deposited, they may find an application by the next day.
Yes, yes.
And it has not been deposited, it is by execution.
No, therefore he prays for listing the matter in the next week.
Right.
Let it be in the next week.
Fine.
They get authorization to disburse it by the executive court as particularly deposited, maybe it is deposited. Maybe disbursed to the amount that's.
No, I have the
Only.
treasury challenge also. Our Lordship may kindly peruse. And all these cases are included.
We are not doubting on that.
Because Lordship, the IIT has deposited the money on 9th of January. But they have given an affidavit on 21/19 saying that that has not been deposited. So they have to file an affidavit saying on record. That's definitely deposited. We are not doubting on that. If it has been deposited, the executing court may reverse it. We are concerned with payment of money. That is all. And that amount is after 30/09/25 only.
No, they have recently received the amount.
Yes.
They will definitely disburse it.
They have money.
As far as item number 6 is concerned, it has to be deposited by the deputy commissioner in the executive court. Not directly.
Yes,
So if they have deposited, now submission is that they have deposited to the executive board also. If that is so, so an observation will make the learned executive board.
no, what Mr. Bhattacharya has submitted is that they have received the amount from the IIT
Yes.
Yeah.
And deposited in the executing court.
and deposited it.
Yes.
Okay. Okay.
So it will disperse the petitioners in the degree holders. What applies to the IIT?
No. Releasing the amount is the duty of the executing court.
Yes.
Executive court will see.
Yes.
It is pursuant to the degree and it has been deposited.
No, no, that-
Why should we assume the charge of the executing court?
Yes.
Not worse. Only the thing is that already they have, the deputy commissioner has deposited 2 crores. And there has been disbursed to the degree holder. The remaining amount of 2 crores, 8 lakhs or something, has still only to disburse. Only the 2 crores.
As per the provision of law, learned will disperse. That is
As per
observation.
Already 2 crores has been disbursed to the degree holder.
You see, this court cannot exercise the jurisdiction under Article 226 before a civil court. So why should we issue such a direction?
If we are paying for any observation, in any case, the lordship may take the lordship to this.
Okay. On Govind, suggest first week of
March.
before that day, you will release it if possible.
That will be released by the court. We have done our part, my lord.
With regard to the one,
So regarding the confirmation that it is being released, for that, my lord, I am praying that the matter may be listed in the first week of March.
Okay, then 2nd of March.
Second.
2nd of March. Okay, we will pass the order.
Obliged.
Timing item,
May I please, my lord, item number 7 of the same order, my lord. Item number 7 is little bit different, my lord. We have no execution court, my lord. It is the deputy commissioner who
No,
directly.
already you have submitted before this court that the matter may be listed in the next.
My,
So we will list it.
lord. Yeah, I will approach. Happy.
timing item 5.
May it please your lordship. Lordship, during the pendency of the matter, petitioner number 5 expired, your lordship, leaving behind 2 heirs, legal representative, para 2 of the petition, your lordship. IA, your lordship, 4087. They may be substituted also.
Heard Mr. S. Ali, learned counsel for the applicant. Ms. Bowman for opposite party, stroke respondent number. Respondent number 2. Respondent number 2. This interlocutory application under order 22 rule 3, read with section 151 of the Code of Civil Procedure, is referred by the applicant for substituting the name of the heirs and legal representative of the deceased petitioner number 5, Srimati Manjuri Borwa. Mr. Ali, learned counsel for the applicant, submits that during the pendency of the writ petition number 5921 of 2022, the petitioner number 5, Srimati Manjuri Borwa, suffered demise, and as such, there is a requirement of bringing on record the legal representative of the deceased petitioner number 5. This is petitioner number 5. Mr. Ali further submits that
Lordship,
this
the
is
matter
petitioner
big
number
for admission hearing in
FBI.
next week.
Who
For
are, who are
admission
the,
hearing in next week,
who are the legal representative?
Lordship.
Who are the legal representative?
Legal heirs is Sri Abhishek Borua and Srimati Pangia Rani Bosumati Para to your Lordship.
Perato.
Para to your Lordship.
Mr. Ali further submits that the petitioner number 5 suffered damage leaving behind one son, namely Avik Borua, and daughter-in-law Pungja Rani Basumotari, Srimati Pungja Rani Basumotari. And as such, Mr. Ali has contended to allow this application. Ms. Bowman submits that. Any objection? No objection.
No.
Submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Sri Avik Borua and Srimati Pungja Rani Basumotari be implemented in place of petitioner. This is petitioner number 5 in the WPC number 5921 of 2022. In view of the order passed in the IN number so and so, Mr. Ali Learned, counsel for the petitioner shall file amended cause title within a period of 1 week from today. You file amended cause title within a period of 1 week from today. Rest shall list the matter in the next week.
Coming item 2.
Amended for slightly.
Next week. In the meantime, you file your amended cause title.
In this case, yesterday I have filed estimate matter that is not record matter. I will take up next time. Next Monday, okay, estimate. No, sorry. You can say, I think it's not, I'll leave it to
Heard Ms. S. Sharma, learned counsel for the petitioner,
On 12.
and Ms. Sutia, learned standing counsel for the respondent in Elementary Education Department. Mr. B. Sharma for the respondent number 6 and 8. Ms. Sutia submits that she has filed the affidavit, additional affidavit, and the same is not. When did you file?
Yesterday, madam.
Yesterday, she has filed one additional affidavit, but the same has not been tagged with the record. And on such count, she pressed for listing the matter on Monday. Where allowed, she shall list the matter on Monday, taking the additional affidavit filed by Ms. Sutia on the record.
Monday, madam. Monday, madam. 13.
13. Okay. 13.
Sorry, number 8.
Yeah, please, Lordship. Here is a case, my lord. My neighbor, respondent number 5, has carried out illegal construction. We put complaint to the municipal authority. Now they took cognizance of the fact and finally they arrived at a conclusion that contained in page 22, my lord. Out of which, my lord, despite the, my lord, the reminder was given, they have not completed the demolition of the illegal construction. And accordingly, my lord, direction was given there too. Page 22.
So
Now,
all the
Lordship,
respondents are present. You have for respondent number?
Respondent number 5, madam.
My lordship, only two things required to mention here. Afterward, my lord, what happened while this matter was ongoing before this honorable court, then we have been directed by this honorable court on 5/5/2025 to file an affidavit taking the consent of my client petitioner that whether if a construction would be suppose demolished, any other thing will happen, then he will be held responsible for them. And purpose to that, my lord, we have filed our affidavit also. Now,
By which order you have been directed?
I have been directed by 5/5/2025.
5/5/2025. But in fact, on 5/5/25, there is no such order.
My lord, we only that has been directed to us, and accordingly, my lord, we file affidavit.
No, on that day, this case has not been listed.
But anyway, my lord, we have filed our affidavit. Now, once we file our affidavit, we mentioned that if suppose this would be work out, my lord, the 21 notice, then we have no objection to that effect. Now, it is this is finality. But on last occasion, my lord, if lordship kindly see,
a direction was given to the government advocate to obtain instruction regarding demarcation part. My lord, in this proceeding, demarcation has nothing to do because, my lord, as so far the demarcation part is concerned, they have already filed a case before the revenue authority that contained in page 61. That is altogether a separate issue, my lord.
No, no.
Therefore, this has to be
Instruction, no, direction was issued to obtain instruction as regard the demarcation of the land.
My lord, kindly see that in their affidavit filed by the respondent number 5,
Mm.
in page 61, they have already filed a case for demarcation, out of which this proceeding is ongoing, my lord.
Mm.
Therefore, so far demarcation is concerned, my lord, is totally out to a separate issue, my lord. And here is a case that we have laid before the Honorable Court is about the illegal construction. Once it has been reached its finality, therefore, my lord, only we have been directed to file affidavit, and that affidavit we have also filed. My humble submission, my lord, that so far this notice is concerned, that has to be acted upon, my lord.
Which notice?
My lord, that municipal board notice, page 21. Page 22, my lord. That is our grievance, my lord. Read petition, page 22, 26/11/2021. That is our ultimate relief, my lord. Matter is pending, my lord, last 3 years, my lord.
Yes, so who is for the respondent number 1 and 4?
And for. I'm for 3 lakh. I'm for 4. I'm for
5/9. My lord, sorry, my lord, order it 5/9, my lord, sorry, not 5/5. 5/9/2025, we have been directed, my lord.
5/9.
Yes, my lord.
But the other council, Mr. Sayola. Okay, can you inform him?
Because you are the boundary holder, that's why, my lord, the consent was obtained.
Let Mr. Sayola come.
My lord, I am the respondent number 5.
He is there.
And who is for 2 and 3?
Kansas Roy is appearing, he's on Lake. Samrat Roy is appearing.
Okay, after some time, I'll let.
My lord. May it please allow. My lord, matter pertaining to non-payment of compensation amount. My lord, I will show 3 orders and 1 affidavit in opposition of the respondent Kala. My lord, everything will be clear. My lord, will kindly peruse the order dated 29/8/2024 first. Start it. 29. My lord, got it, my lord.
29.
29/8/2024. Order passed by this honorable court. Order, court order. Yeah. No, sir, I would not fight it. 29.
No such order is there.
Hello, this is an order dated 29/8/2024 of this honorable court.
Yes.
My lord, may I read it now? Heard Mr. So-and-so, Learned Counsel for the petitioner also heard Mr. So-and-so. Now, my lord, second paragraph. The present writ petition is filed with a grievance that though compensation amount of rupees 50,21,953 was determined as structural compensation in respect of the property belonging to the petitioner, the said amount has been paid to the private respondent who is not entitled for structural compensation. From the materials available on record, it is also seen that the Assistant Commissioner Land Acquisition Office Jorhat has already lodged an FIR before the Superintendent of Police Jorhat District, Jorhat, affirming the said facts alleged by the petitioner that land acquisition compensation has been wrongly paid to the respondent number 8, though the petitioner was entitled for such compensation. In the aforesaid backdrop, the competent authority, that is the Assistant Commissioner Land Acquisition, shall file an affidavit incorporating the following facts. These are the facts which was directed to be incorporated in the affidavit. Now, my lord, they have filed the affidavit. Will kindly peruse the affidavit filed by the respondent number 5. 183. My lord, this is the competent authority for land acquisition, Kala. He has filed this affidavit. My lord, will kindly see the relevant para at page 9, para 10.
Page number?
Competent authority for land acquisition, my lord, respondent number 5.
Affidavit dated?
Affidavit, my lord, dated. This is the affidavit in opposition. 1/10/2024.
11 to the half of it. 11 to admit chorus, 10 to 11 to admit.
By respondent number 5.
Yes, my lord. Respondent number 5.
Yes.
My lord, will kindly see para 10. Para 1 to 9, they have stated the facts. My lord, will kindly see para 10. May I read, my lord? That with regard to the statement made in para 17 of the petition, I said that the authority took all possible measures to recover the disbursed money from Probin Bora, son of Rajani. In this regard, 4 letters were written to Jorhat Police for registering case against Probin Bora, son of Rajani. In this connection, the Superintendent of Police Jorhat informed the Deputy Commissioner Jorhat that a case numbered as so-and-so was registered and charge sheet number 22/17 dated 22/2/2017 under section so-and-so against Probin Bora, son of Rajani, for trial, and the matter is sub judice in the court of SDGM at Jorhat. Moreover, Probin Bora, son of Bhupati, himself approached to the Chief Vigilance, Special Vigilance Cell Assam, and a case was registered by RE number 11/2019. That I further said that steps for payment have not been initiated. Now, my lord, will kindly see para 11. That with regard to the statement made in para 18 of the petition, I said that Probin Bora, son of Bhupati, refused to accept the land and Zirat compensation entitled to him. Therefore, land and Zirat compensation along with enhanced land value of Probin Bora, son of Rajani, was sent and deposited at the bank as per direction of the Court of Learned District and Session Judge, Land Acquisition, Rehabilitation and Resettlement Authority, Jorhat, via LA reference case number 13/2022. Since the structural compensation was already received by Probin Bora, son of Rajani instead of Probin Bora, son of Bhupati, hence the matter was then only to recover and to hand over the same to the right person. Steps for payment could not be initiated for direct payment of the same structure, that is double payment to Probin Bora, son of Bhupati, of his own, unless an order for payment is received from the Honorable Court. Now, my lord, will kindly see the 3 questions which this Honorable Court raised on the last occasion. This was answered. As regard to the first question, my lord, yes, the petitioner was entitled for compensation of the structural damage. Your lordship kindly keeps 2 orders hand by hand. In the order dated 29, it was says whether the petitioner was entitled for compensation as claimed in the writ petition for structural damages. It was answered, yes,
the petitioner was entitled for the compensation for structural damages. Now, in regards to question number 2, yes, the facts narrated in the FIR lodged by the then Assistant Commissioner Jorhat are correct. As regards to question number 3, the compensation for structural amount has been disbursed to the respondent number 8 as per 3G list in respect of DAG number 440, but the said structure was actually situated at DAG number 426 and 428, which structure belongs to the petitioner. Now, my lord, based on this affidavit in opposition filed by Kala, my lord, this honorable court, my lord, had passed an order on 23/9/2024. Will you kindly produce that? Kindly peruse that order, my lord. 23/9/2021. Oh, sorry, 24. 23. Your lordship got it, my lord.
Yes.
This court, under its order dated 29/8/2024, directed the respondent Kala to file an affidavit on the following grounds. An affidavit has been filed by Kala, which is quoted herein below. My lord, these are the answers which have been stated in the affidavit. In view of the aforesaid, it is prima facie appears that the petitioner is entitled for compensation amount as claimed and sanctioned. However, the question shall still arise, who will pay the compensation? At this stage, learned counsel representing Kala and Mr. So-and-so, learned standing counsel NHI seeks a week's time to obtain instructions. Prayer is allowed, list this matter on so-and-so. Now, my lord, from here on, my lord, the matter gets, every time when the matter gets listed, my lord, one way or the other, my lord, time is taken to obtain correct instruction, whether payment will be paid by Kala or payment will be paid by NHI DCL. Now, my lord, yes. Now, my lord will kindly peruse the order dated 9/1/2025 again. I'll just trouble your lordship with last order. 9/1.
9/1.
2025.
Yes.
Now, my lord, the facts which your lordship had already perused, that has been elaborately stated by this honorable court. Now, my lord will kindly see para 7. Seven, 8, and 9. Now, my lord, the land has been acquired in the year 2009. Today is 2026. More than 17 years have passed, my lord. I'm still in the limbo.
Mr. Borua is available today in the court?
My lord. In the last occasion, my lord, the record was called. Last two occasions.
Mr. Monto, you are appearing for?
The other Provin Bora.
Yes, is it that one?
No, my
I also have my property also for my house also demolished minor. It is specifically stated in the minor report of the 3G. There is no evidence that any structure of the land of the minor is just reported comes to the respondent fine. And moreover, when somebody criminal case in this, I have already acquitted. The prosecution really failed to put the anything from that is also I have given the all record of the
affidavit as affidavit of NHI DCL.
But Mr. Borua is absent today.
My lord.
Are you heard?
He is absent.
Whether the instruction is available with you?
Yes. We have been on compulsion from Kala. We cannot decide who is to be paid and who is not. So whatever Kala tax, we just pay the money. That is that.
Yes.
We have filed a affidavit lawsuit. Initially, he also asked that he will refund the amount lawsuit. Subsequently, he did not lawsuit. There is private respondent lawsuit. He not affidavit lawsuit. I am not concerned whether the respondent Kala takes from respondent number 6 and give it to me. My case is, my lord, they can release it to me. Later on, they can initiate Bakizai proceeding or whatever appropriate steps they can take it. But how I will be deprived, my lord? That is my question before this honorable court. And already everything has been admitted. And in fact, my lord, this particular structure was there till 2024. In fact, the National Highway authorities had filed their affidavit in opposition, stating that because of this structure, the road has been constructed, but the structure is in the middle of the road. Now, because of that structure, public hazard is occurring. So, but once this affidavit was filed by Kala stating that yes, I'm entitled for compensation, I directed my client that allow them to demolish because it has now already been accepted. And that has been stated in the affidavit filed by NHIDCL. Now again, if this question comes up that whether there was structure or not, now nothing is there. Because I only asked them to demolish it. Once the Kala has accepted, yes, there was structural compensation and you are entitled for that particular structural compensation.
So it is in the affidavit itself.
Yes. Well, there is an affidavit which has been filed by NHIDCL on 27/6/24. If your lordship sees, para 15. What's the structure to declare?
At page number?
Page number 106.
Yes.
I will see from the top 5th line. Moreover, 5th line minus page 106.
Yes.
Moreover, it is prayed before your lordships that the petitioner's structure is standing in the middle of service road, which is a dangerous safety hazard and may cause serious road accidents resulting in loss of life. Therefore, your lordship may kindly consider the public interest and not stay the demolition of the building. Now the structure is no more, my lord.
So you are representing Kala. So who will pay the amount now?
Already lawsuit, he has received this part lawsuit. And in our affidavit lawsuit, page 185, para 6. If the lawsuit, that person appeared before and he paid for 1 month time to refund the amount deposited in account which expected to be done to him. Particularly cancelled. Page 185, para 6. Page 185, para 6.
You pay the amount
Yes,
and
sir.
recover it from the person concerned.
Well, he is present also lawsuit.
Whatever they are saying, they are on a they say that I have something, the demand is a specified. They are saying, they are separate. I am never saying this, I will demand. Moreover, my kindly come to my lord, to next para of their affidavit, pay para number 8. Their affidavit. That it is specifically said that while denying the paragraphs of the statement made in 11 of the picture, I say that A is not genuine as the LA Allah is taking all possible necessary steps upon the respondents made by the community son of So whether whatever they are giving, I am not on that matter. There might be my structure also, there might more shop rooms, my house, RCP would be, sometimes that is been my money against that point, along with my other studio producing, so money was given to me and being a part of the mother, I have and money has been distributed to all. So now the question is, whether the at the time of the money, there is any proof that would show that the particular any construction or structure was over there, then circular instance question. There is no any proof. So there is no any report also in checking. So
No, we'll not go into that question.
but that is
Ah.
whatever available I have received and so far cases here. I have equity. I am not in the.
No, we are also not concerned with the acquittal of in the criminal case.
But
We are not concerned with
but
that.
they but thing is there, but they have to prove that I am not entitled to money. Then they can go for recovery. But on the basis of my statement, only they say that I have confessed. I have never confessed anything to anybody.
I'll take it up lot in the
How many dates you have already taken? How many dates you have already availed for obtaining instruction?
One thing, my lord, I have obtained the certificate copy of this order of.
If that is your stand, then we will pass order along with the compensation. Oh no, sorry, along with the interest.
Give me a month. Next week.
You pay interest at the rate of 18% per annum.
From the respondent. Last opportunity.
My lord, 8 to 9 occasions they have.
Okay, let it be on Monday.
My lord,
Monday.
Monday.
Heard me, sir.
K. Mohammed.
Learned counsel for the petitioner. Yes, sir. Goswami for respondent number.
Respondent number.
I got 5, 6.
5, 6.
5 and 6, Mr. Mohanto for respondent number.
8.
Respondent number 8, Mr. Borua. Respondent number 20, Mr. Bhattacharya for. Respondent number 4. On the pair being made by Mr. Goswami, learned counsel for the respondent number so and so, the matter stands adjourned to be listed on Tuesday. So as to enable him to obtain up to that instruction, pair allowed, recess a list the matter on Tuesday as part of.
10 February.
I'm deeply obliged.
Learned counsel for respondent 2 and 3 present.
Lordship, my instruction is that, Lordship, we are ready to demolish, Lordship. We demolish, there some portion will be damaged. Then he has to take undertaking that he will not claim any compensation. File our affidavit, madam, that will be. We are ready, we have no objection if some damages happens to his property. Demolish this unauthorized, his property will.
We'll take care, madam. This is our part, madam. We have filed our affidavit also, madam.
We are not able to demolish because his property will be damaged. If he takes an undertaking, most of the.
We have given affidavit, my lord.
If he takes undertaking, then we are.
That can be, my lord, disposed of, my lord.
With the observation that he will not claim any damage.
Yes, my lord, absolutely. My lord, page 22.
And where is your affidavit?
My lord, my affidavit, my lord, page 119.
31.
Filed on 31/10/2025. That's why lordship, a direction was short form.
this honorable court.
1-1.
My lord, affidavit my lord, filed on 31/10/2025, page start from 119, my lord.
Then where is the particular averment?
My lord, they contain in my lord paragraph 2 and 3, my lord. Paragraph 4, we have clearly stated, we don't have any objection.
But they have not taken undertaking that.
No, we have given, no, on affidavit, paragraph 4, kindly read.
They have no objection.
What undertaking you want to?
Any damages happen to their.
My lord, this is not a issue. My lord, issue this honorable court pass a direction.
Issue is, was this was.
My lord, direction was given by this honorable court to file an affidavit saying that we do not have any objection.
For taking.
If this honorable court comes to this conclusion, my lord,
Demolish their.
will not claim, my lord. We definitely not claim, my lord.
That was not in the affidavit.
That is not required, my at all, my lord. If suppose it is a matter
No,
of, my
no.
lord,
If tomorrow any damages
my kindly see, lordship,
goes to your property,
yes,
then
I make the position. My lord, this entire matter has been dealt with by this honorable court numbers of time. Then finally arrived at a conclusion that suppose if this 21 notice should be acted upon, then whether we have any objection or suppose any damage caused or any cost, whatever, then we have been directed to file affidavit saying that whether we have objection or not. Then on record, we have brought this fact that we don't have any objection specifically pleaded in paragraph 4, my lord. That's enough, my story. If any damage will, I will be there, man. I will bear, my lord.
Lordship, this was in our affidavit.
Unnecessary. They are supporting, my lord, otherwise.
If some damages will cause, they will not take this, observation court was asked.
no, they have given no objection means they have undertaken the risks.
That was not specific.
Maybe.
Damages, no objection is always there, Lordship. If we go to break their building will also damage. Then they will come up for that.
My lord, why we come, my lord? We know that nothing will happen to us. If happen, my lord, we'll bear the cost, my lord. That's why you given that. If,
That observation may be
Okay,
there,
then
Lordship.
we'll record your
Yes,
observation,
madam.
record your undertaking.
Yes,
Okay,
madam.
we are disposing of this petition.
Lordship.
My lord.
Then demarcation itself, because management kindly come to page 94. The step taken by the municipality.
Page number 94.
Affidavit is.
They also a separate issue, my lord. That's why they want to club together again and again another story.
That demarcation, because by the demarcation, how can they ascertain what is the specific that is to be demolished? There's the boundary what has to be ascertained from what the boundary, what is the quantum of amount that is to be demolished. Unless the boundary has been quantified.
My lord, it is not a matter of demarcation to be dealt with because my lordship, they file a separate case, page 62 of their affidavit, demarcation. If suppose they could not pursue this demarcation, how they can restrain the municipal board to act upon on a notice which they have already arrived at a conclusion, my lord. That's why this honorable court look into this whole aspect in entirety, and we have been directed to file an affidavit. That was the final stage, my lord, and we have filed our affidavit. That's why, my lord, nothing remains furthermore to reopen the issue of demarcation. Demarcation, if you have, you go to the revenue authority, which we have already filed their own. They are unnecessarily expanding the issue, my lord. In a different dimension, my lord.
In 920. The second paragraph. file respondent number 2 and 3. My lord, comparing it up to page 97 of that data. Filing 24, those orders came out in 25.
My lord, 69 is about something else, my lord. This is lordship in pursuant to our instruction, my lord. My lord, kindly, just lordship, only one point, my lord. Lordship, kindly. Lordship, entire facts has been summed up, lordship, entire facts has been summed up finally by virtue of the order passed by the Honorable Court on 5/9/2025. Entire facts has been already considered and finally my sum up 5/9/2025, out of which we have been directed to file an affidavit, get on instruction, my lord, based on instruction. That we have complied with, my lord. Now they can, they now cannot revert back the situation, my lord.
Page 104, 104.
Yes, you are referring to page number
104.
97. Yes.
And third paragraph, my lord, subparagraph. It is further submitted. The methodology. Subparagraph. It is further submitted that in the absence of the proper demarcation of the land in question, the exact position cannot be ascertained. The boundary wall on the southern side of the respondent is adjoining wall and there is no gap in between. Had it been the common boundary wall, the construction of petitioner's shop also should have been there leaving the requisite sizes. Setback has not so the prevailing building law bylaws.
Page 104.
104 is important, my lord. Affidavit, they have filed, my lord.
We have filed. The affidavit filed for the respondent number.
They're taking the departure from the facts, my lord. Page 104, my lord, they have filed affidavit that they are ready to, my lord, demolish the work. Now they are saying demarcation. Demarcation is totally separate issue, man. Nothing to do with this instant proceeding, my lord.
Yes, 104.
Page 105, check. That's for the affidavit filed by the respondent number 5.
Paragraph number?
5. 105, paragraph 5.
Yes.
That as per the telephone decided with the further status, she demolished the deviation portion of the thing and the construction toward the petitioner after coming from the medical care.
On affidavit, it is stated.
He has stated in order demolition.
I have no objection as regards demolition. My only thing is that what is the setback? How much quantum I need to demolish? Until and unless the proper demarcation.
Municipal board is there, my lord.
I cannot ascertain because my allegation is that there is enforcement of land from this side.
No, this is your affidavit.
Yes, and I understand that. There is no, I am not disputing that I am not demolish, provided that the demarcation comes. They are ascertain what is the setback and from which end that setback has to be quantified.
Demarcation is totally out to a separate. Whoever supposed to carry out the illegal construction, me or he, whatever, my lord, without permission or whatever, then they have to face the consequences. Demarcation, suppose it will come in between, my lord, afterward also. Then the parties will bear their own cost, my lord. But in between, my lord, demarcation cannot be a cost to suppose stall the proceeding of my lord, municipal board. And it is their affidavit where they have stated they are agreed upon, my lord. Now they are saying something else, my lord. And entire thing, my lord, kindly see my entire, my lord, this matter has been hard, my lord, this matter has been hard in length, my lord. Finally, this honorable will come to the conclusion that the notice dated has to be acted upon. That's why, my lord, the confirmation is sought from us by way of affidavit that if suppose carried out, if anything happened, are you ready or not? We said we are ready to face the consequences. In the end of the issue, my lord, nothing remains. Again, revert back the situation. That has to be acted upon, my lord. Nothing remains, my lord. (26/11/2021). Municipal is ready, my lord. We are ready. They are also ready by virtue of affidavit. Now they are taking the plea of demarcation, which has nothing to do with the present proceeding, my lord.
No, without any proper assessment or without any proper demarcation, the municipality has issued the notice.
Well, That is my page 94.
Hmm.
Just take municipal page 94.
No, demarcation is not the subject matter of the municipal board. Municipal board, we only see that in terms of the permission, construction has been carried out or not.
Page 94.
That's why, my lord, they have issued the notice out of which they made their reply, my lord. And finally, my lord, the municipal board come to the conclusion that it is a illegal construction. And my lord, direction was given. Pursuant to that, they have also filed affidavit saying that we are ready to demolish the part of construction. Illegal construction.
The demarcation could not be undertaken because of non.
And now they are saying about demarcation, out of which, my lord, a case they have instituted, my lord, which is pending for disposal.
Page 95.
Now, anyone's construction which is illegal, either this or that side, my lord, they will bear their own cost, my lord. But for that purposes, my lord, the authority which is, my lord, empowered under law to carry out the demolition part, my lord, that cannot be restrained, my lord. And this matter has already been heard in length, my lord, by this honorable court. About these demarcations, reply everything, my lord. And finally arrived at a conclusion by virtue of order 5-9, my lord. That is the, my lord, last part of the proceeding.
At page 97, municipal. Without there being a proper demarcation.
My lord, if they don't have the demarcation, how they have obtained the, my lord, permission for construction, my lord? Kindly ask only one question. Suppose a person has in particular demarcated land, out of which he applied for permission. Permission he has obtained. Now he is deviated from the permission. The municipal body now acted upon that, my lord. Now who is this fault, my lord? If you don't have the demarcation, then why you have applied for permission and why you have obtained the permission? Why you have carried the construction?
My permission is not actually.
It is not an issue of challenge. It is a matter of that has been debated. That is our case at all.
Page 94, municipal tickets themselves. There has been non-cooperation by the petitioner regarding the demarcation.
My lord, again, they are coming to the side of demarcation, my lord.
There has to be proper system. It's an feedback that has to be.
Mr. Samuria, why you have not cooperated with the circle officer for
So far,
demarcation?
the demarcation part is concerned, there is no issue of non-cooperation, my lord. Notice has been issued, my lord, we will follow the proceeding. If not, my lord, they will act upon, my lord. That is the law, my lord. It is not a case of suppose if we fail to cooperate, they can go ahead, my lord. We have to face the consequences. But how it is a matter of demarcation come in between, my lord, here. There is a case, my lord, you have already demarcated your part of property. And based on that, you applied for permission, you have obtained. Afterward, you carried out illegal construction. That has been objected. Now it is a time for, my lord, take action. And you have also agreed upon by virtue of affidavit saying that, yes, we are ready, my lord. If this is so, my lord, that no, my lord, notice can be acted upon, my lord. If suppose this situation will come again in a demarcation, in the plea of, my lord, in the garb of demarcation, my lord.
No, that's all right. It appears that the circle officer has attempted to make a demarcation. And you have hesitated before the circle officer and
Lord,
non-cooperated.
can I make only one clarification? Suppose, my lord, take it for a moment, that demarcation is, take it for a moment. That demarcation is this side or that side, some area, this or that side will go. Okay. Now, a construction which is apparently illegal, that required to demolish. Suppose if it remains within my side or their side, that is not the issue at all, my lord. No, lord, I am saying that suppose if I would carry out the illegal construction, I will face the consequences. If you carried out the illegal construction, you have to face the consequences. In between, my lord, demarcation has no role to play at all. It is a case of structure which is illegal, apparent, and that has been found by the concerned authority on verification, my lord. Out of which they want to act upon that. That's why, my lord, a precautionary measure has been taken care of by the Sonobal court, saying that if suppose something else, are you ready to bear the cost and other thing? We said, yes, we are ready to bear the cost. Now, what remains more, my lord? It is their affidavit saying 104 page, my lord, that we are ready to, you never objected it because of the demarcation issue, we would not suppose agreed upon.
What I suggest, Lordship, that we also to the circle of visit to demarcate the land within 45 days and within 15 days, we will do the demolition, unauthorized construction, Lordship. What I suggest.
Again, my
my
lord,
suggestion.
new round of litigation.
Litigation, Lordship, we will, with the time frame, Lordship, may direct the circle of visit to demarcate the land, we will demolish the unauthorized construction. If all the parties are very clear, Lordship, all the participants will.
Yes.
That can.
My lord, kindly see. Ultimately, both go in their court, my lord. What I'm saying, my lord, demarcation is at all a issue, my lord. Take it for a moment, my lord. Suppose demarcation 5 feet either this side or 5 feet that.
No, why you are objecting?
That's why they ultimately gain the benefits, my lord, in the name of demarcation.
The question of getting benefit.
What I'm saying, my lord, suppose
does
demarcation.
not
Suppose, Lord, just only moment. Demarcation suppose come to my side. Take it for a moment, my lord. There is a structure that will be demolished, then I face the consequences. Demarcation go to their side extending 5 feet. Suppose take it for a moment. Then they have to face the consequences. Here is a case about illegal construction. Here is not a case of demarcation this side or that side. They have pointed out that this area contain a construction which is not permissible under law. It required demolition. That is their authority, my lord, to act upon, my lord.
Let the circle officer make a demarcation, then thereafter they will carry out the.
Just one statement. If the land of the.
You are for?
I'm for the petition only, Your Honor. I'm the
No,
local
he
counsel.
has already appeared and argued before the court.
So extremely. Now, Lordship, whatever Lordship feel good, well, we have nothing to do. We just place our case and Lordship decide the issue. We will follow accordingly.
Okay. We're disposing of the petition.
My lord.
In these cases, we has right to file immediately. Very break even, here documents is burning. That is translated, so we first time different.
My lord, the issue in this case is that the petitioner approached the revenue authority for demarcation of this land. The private respondent filed a writ petition. Then ultimately this honorable court directed this circle officer to demarcate our land and record corrections. My lord, we challenge this circle officer order. There is no whisper that any demarcation was done, and not to speak about record corrections. Now, this last occasion.
Mr. Borua,
My lord.
you see, they have not filed their affidavit in opposition. Now, without their affidavit in opposition, can we dispose of the matter?
No, my lord.
Yeah. Let them file affidavit.
Yes, what I understood, my lord. My lord, this order is ex facie, prima facie is illegal because they admitted that demarcation was not done.
Okay,
So-
we'll hear you.
Yes.
We'll decide whether it is
So,
legal or illegal.
next week, and because from November, December, they have taken time. And why they cannot do it, I have that, I mean, hearing I will
No,
disclose.
now he has submitted that their affidavit is ready. You will be filing within 1
Yes.
week from
So,
today.
short accommodation may be given because from 4 or 5 days they have submitted this only.
Heard, Mr. M.J. Borua, learned counsel for the petitioner. Mr. You for respondent number? You. 2 and 3. 2 and 3. Mr. Roy Chaudhary for? 4, 5 and 6. 4, 5 and 6. The learned counsel for the respondent number so submits that their affidavit is ready and may be granted 1 week time to file the same. They are allowed. Yes, last chance. Let's just release the matter on. We'll fix it at
18th February.
18th of February. 18th of February.
Item 12.
May I appeal, Lordship?
Yes.
Here in this case, Miller, where the 6 ward elected ward members of Boraja Gaon Panchayat and the respondent, Miller, private respondent, are 4 elected ward member, Miller. In the first meeting, Miller, 6 ward members proposed the name of petitioner number 1 and 2 as a president and vice president, and other 4 members proposed the name of respondent number 8 and 9 of the as a private respondent as a president and vice president, Miller. But the respondent number 5, I decided to hold the selection and election of the president, vice president, Miller. But ultimately, Miller, a first meeting was not held. Subsequently, I came to know that arbitrarily and illegally declared the respondent number 8 and 9 as a president and vice president. The petitioners immediately on 2/7/2025, as per section 11 of the Panchayat Act, submitted representation before the deputy commissioner, highlighted the grievance, Miller, and thereafter, Miller, subsequently 14/7/2025 also submitted representation before the deputy commissioner. The deputy commissioner on last 23/7/2025, hearing was conducted, Miller, and statement of the 10 ward members, including the petitioners, were recorded. But till date, Miller, a result were not declared of the hearing. Of one, I kindly see page, Miller, or hearing page 59.
Page number?
Page 59, 59. This is the affidavit filed by the government, Miller. Page 59. Petitioner number 6, statement of the petitioner number 6, Miller, Shehnaz Begum. Like that, Miller, other.
So when the hearing was concluded,
23/7/2025.
is there any document to substantiate the same? That hearing was concluded on that day?
Yes, Miller, that is the
Page
affidavit
number?
filed by the respondent, Miller. Kindly see page 54, Miller. 54, paragraph 6, Miller. And in my writ petition also, page 48/49, notice was served for hearing. Page 55, para 6.
Okay.
So the officer concerned who has heard the parties has been transferred.
Yes.
As per this paragraph number 6 of page number 55. Who is for the respondent number 4?
I am agreed for 2, 4, and 5.
2, 4, and 5.
Respondent number 4, co-district commissioner.
Do the erstwhile co-district commissioner heard the matter, he was transferred before passing any order. Now you complete the hearing and pass the necessary order.
With this direction, it can be this problem.
Yes.
But only thing, hearing already concluded.
No, the person who heard the matter, he is transferred.
So the question, your lordship kindly see there affidavit, my lord. Yes, already your lordship has seen, my lord.
Paragraph number 6.
Yes. No, statement, page, yes, paragraph 6. So he has been transferred, so it is deferred to me. So let them dispose, my lord.
Yes, after conducting fresh hearing.
No, fresh, already hearing has taken place, my lord.
No. Hearing whether he has recorded the statement.
Yes. Page 59.
Page 50.
59.
Hmm.
8 to 59.
Yes, page 59 can be seen. All my lord statements are there.
1, 2, 3, 4, 5, 6. 6 petitioners and what did for?
All the 6 petitioners, their statement already recorded, madam.
Including.
It is on the record. We have annexed it, madam. The statement of all the petitioners as well as petitioner 6 person and other side is 4 person. Problem is, my lord, once your lordship is an election matter already, my lord, so it will take time, my lord. Once a fresh hearing, because everything is record, my lord. On the basis of this statement, let them decide, my lord. On the basis of statement which
Yes,
already.
any bar in deciding the matter on the basis of the statement already recorded? So statements are already recorded.
Yes.
So on the basis of this statement, the matter can be
Yes.
disposed of.
It can be started from that point.
After statement. On the basis of the statement. Yes, madam. That is what I am saying, madam. It will save time, madam.
Okay, I will pass the order then.
Madam.
And this exercise has to be carried out within a period of 1 month from today?
No, 1 month into 2. Everything is on the record, my lord. Only they have to give the findings, my.
No, he
On
has
the basis
to
of the.
Notices
No, no.
are to be served upon them by.
Already served.
Hmm?
Already served, already appeared, already recorded.
Whether,
It's for the one case in that case.
no, whether fresh notice is required. I don't think.
One person is again hearing that order passed into another person, then it will be disputed down. Because if one officer contacted hearing, then order passed to another officer, then still dispute will come.
No, statements are already recorded.
On record.
On the basis of those statements, the person concerned can pass the order.
Yes.
Where is the bar?
Yes. My lord, 2 weeks.
No, even then,
Yeah.
if the person concerned, he desires to hear both the parties, then he may hear.
It is up to the
Yes.
authority who will decide. madam.
Then he'll have to put on that.
Yes,
He'll have to be put on.
okay. So whether notice is required to be issued, I don't think so.
No, notice is not because he is appearing, my lord. They have to pass the order, my lord. Though not necessarily the parties, my lord. If the thing, suppose the authority thinks that parties attendance is required, my lord, that is another thing, my lord. Otherwise, only the department is to dispose the matter. my lord.
No, the outer limit may be 1 month.
Outer limit. my lord.
Yes,
With-
within 1 month.
Within 3 weeks, my lord, preferably not later than 3 months. So that.
3 weeks.
Some right of it. Yes.
Yes.
Oh, similar order, that
3 weeks.
please oblige to us.
Lordship, in this case, as far as I have received one instruction, Lordship. But in respect to the pair of the petitioner, and the instruction received. But when the matter will be on Thursday next, I have obviously put my Can Lordship, so for final proposal, Lordship, I will have to place a form below.
Next Thursday.
Next Thursday, Lordship.
Okay. Heard Mr. N. Bora, learned counsel for the petitioner, Mr. P.P. Dotto, learned standing counsel for the respondent in secondary education department. Mr. Dotto submits that he has received the instruction and he prays for listing the matter on next Thursday. So as to Thursday, and on that day, an endeavor may be made to finally hear and dispose of the matter.
My
They are allowed to list the matter on Thursday.
problem will last 10 years, I am not going to appear for the promotion for the post of headmaster. Again, this issue should, if they are.
Okay, let us wait and see till Thursday.
madam. March. March.
Item 13.
May it please your lordship. The petitioner's bank account is freezed for more than 18 months, your lordship. And it has not been resolved, your lordship, till now. Recently, an SOP has been issued by the Ministry of Home Affairs, your lordship, and in that SOP also it is said that a bank account cannot be freezed beyond 90 days, your lordship.
You have filed your reply.
Yes, your lordship. Admittedly, lordship, the petitioner used to play online games, your lordship, but at that point of time, the online games were not banned in India. It was regulated only by the Online Gaming Regulation Act on 1/10/2025. So at that point of time, playing of online game was not banned in India, your lordship. Also, they have filed their affidavit, but it is not supported by any record, your lordship. And the bank has filed their affidavit. And in that affidavit, only transaction amount is shown, not the disputed amount, your lordship.
So you have received the copy of the affidavit.
And I've been praying for the respondent number 2 and 3, State Bank of India, my lord.
Yes.
This helps my affidavit, page 39, paragraph 5.
So these transactions are prior to the new enactment.
My lord, these were the complaints made against the petitioner's account, my lord.
These are the transaction amount, your lordship.
My lord, on a particular single day, my lord, on a
Hmm.
single day, these transactions, high value transactions were made in the petitioner's account.
But they have not supported it by any document, your
I'll come to
lordship.
that one. I'll come to that one. So these complaints were made, and on the basis of these complaints, my lord, when the matter was reported in the National Cybercrime Reporting Portal, my lord, automatically the account is frozen by the concerned bank, my lord. Because if the money goes out, my lord, the beneficiary which of course been defrauded, my lord, there will be a difficulty to get back the money. That is why, as a precaution, this account was frozen, my lord. Then, my lord, the matter was taken to the court, my lord, and there is one amount has already been, there is an order from the court, my lord, regarding
Lordship, as per my instruction, by that court order, 1,45,000
45,000
has already been paid from his
Now,
account.
there is another court order, my lord, regarding this, 28 lakhs 40,000, my lord.
Lordship, the petitioner is not engaged in any cyber fraud, Your Lordship. He used to play online games. That is the thing, Your Lordship. And online gaming is not banned in India.
And this complainants, my lord, the account was verified and it was found that the amount which was deposited in the petitioner's account came from that particular complainant's account, my lord. So this is the statement of account, my lord. On a particular day, how many transactions, high value transactions, my lord. Massive transactions, my lord.
Lordship,
The
whatever,
complaint pertains to this transaction, my lord.
Lordship, whatever be the transaction,
This
can
is
they
under the
keep,
adjudication of the competent court.
can they keep my account frozen for more than 18 months, Your Lordship?
There is last, another court order is there, my lord, for recovery of, 28 lakhs 40,000, but this we could not recover because the balance in the petitioner's account is much less, my lord.
Lordship, I am not aware of this court order because in this 18-month, I was not summoned to any police station or cyber cell. Neither any summon was issued to me to appear before any court, Your Lordship.
Petitioner has made this, respondents, my lord, respondent number 4, 5 and 6, my lord. They are the respondents in this writ petition, my lord.
They have not appeared before this court, Your Lordship, in spite of receiving notice.
It is based on that instruction that we are acting, my lord. All over the country, there are various frauds coming up, my lord.
So in your affidavit, you have mentioned about cases registered against the petitioner's account. Do you have any document to show, to support these claims? Is A, B, and C in paragraph number 5.
My lord.
Any document in support of this contention?
These are mentioned in the statement of account, my lord. The transaction number and everything is mentioned in the statement of account, my lord.
Whether that statement is part of your affidavit,
No, my lord.
then you file an additional affidavit?
Lordship, may I give you some time? I will try to get the latest status of this complaint, whatever it is, my lord. time will be given so that I can coordinate with the other authorities also, my lord. So it is not pertaining to this particular branch only. These are all 10 Indians. So some are there in Tamil Nadu, some are there in Puducherry, and some are in Telangana. So I will try to gather the status, my lord, and find a detailed affidavit, my lord.
Lordship, more than 18 months, your lordship, they are keeping my account frozen and still they are not in a position to give the status of what the regarding the latest status of the complaint against me, your lordship. Maybe the person who has logged logged
They
against
have
me in the
in their
We have to satisfy that these transactions against which these complainants come, that is the genuine transaction, my lord.
Lordship, it is onus on the cyber cell, your lordship.
That is why they are investigating, my lord. On the basis
It
of that,
more than
more
18 months, your
45,000
lordship.
has already been reported back to the victim, my lord.
More than 18 months, no summon, nor neither I was asked to appear before any police station or cyber cell, your lordship. If 28 lakh is defrauded, then I should have been summoned to some police station, cyber cell during this period, your lordship.
okay, we'll grant you 1 week time. You file affidavit.
2 weeks, my lord, because it is a pan India thing, my lord. I have to get all of everybody, my lord.
No, you mainly file the relevant documents in respect of A, B, and C
A, B, and C, yes, my lord.
of the paragraph number 5 of your affidavit in opposition.
My lord, I will also try to get the latest status.
Okay, okay.
Lordship, moreover, there is an SOP by the Ministry of Home Affairs, your lordship. It has come into force from 2/1/2026.
So is it part of your record?
No, your lordship, but I have brought the SOP.
You file it by way of an additional affidavit.
Only the relevant portion, your lordship.
Yes, relevant person.
Uh.
Third Ms. F. Hussain, learned counsel for the petitioner. Mr. Borua for the respondent number 2 and 3, and Mr. Talukdar for the respondent number 1. It appears that Mr. Borua, learned standing counsel for the respondent number 2 and 3 have already filed their affidavit in opposition, and in the paragraph number 5, Mr. Borua has referred to 3 cases registered against the present against the account of the petitioner. However, in support of the aforementioned complaints, the aforementioned cases, no document has been enclosed with the affidavit in opposition to substantiate the same. Accordingly, it is provided that Mr. Borua shall file an additional affidavit bringing on record the aforementioned cases registered against the account of the present petitioners, and he may also file the present, and he may also bring on record the latest status of the investigation being carried out against the account of the present petitioner. Present petition. Ms. Hussain, learned counsel for the petitioner, also submits that the Ministry of Home has already issued one SOP.
Lordship.
And she submits that she may be allowed to bring on record the said relevant portion of the said SOP by filing an additional affidavit. They are allowed. List the matter after 2 weeks. We'll fix it that on
23rd.
83rd. Mr. Borua, you keep this document.
25th, madam.
Not 25th, your lordship. 26th, your lordship.
26.
26.
Mr. Borua, you keep this document with you. You submit it on next day.
This document I'll take it.
Lordship, that court order. Lordship, the
I'll give it to you. I'll carry it to you.
court order should be.
Whatever document I'll carry it.
Lordship.
Okay. So we'll resume after 5 minutes.
Number 14.
May it please the Lordship. My lord, before I proceed, my lord, important development have taken place in this matter. Just wanted to, my lord, place order passed by a coordinate bench of this honorable court, wherein, my lord, the similar, my lord, cause of action had arisen, and the same and notification that we have put to challenge was also challenged in this particular case, my lord, which was subsequent to the order passed by this honorable court in our case, my lord. Now, today I have just a small humble prayer actually. On the last occasion, the court has issued notice and have given a direction to the respondents to file their affidavit because there is a time limit, my lord. Because time limit is why, my lord, the petitioners, they are basically IMFL, Indian made foreign liquor, my lord, retail unlicensed shop holder operating in rural area in the district of Dibrugarh, my lord. Now the point is on 15th of February is the last date of filing their renewal for renewing their licenses, which is given for 1 year, my lord. So, my lord, the issue before your lordship is that before renewal, there is a notification which has come, which they are saying that we should immediately register ourselves under the VAT Act, that is Value-Added Tax Act, 2003, my lord. Now, we are challenging that order on the ground that, my lord, we have been operating for last 3 years, since 2022, and in no occasion, my lord, they have forced us or compelled us to register. And we have been paying the VAT regularly through a system, which I'll come when I'll take a lordship to the papers, by paying a prepaid form of tax before we lift the stock from the wholesale warehouses. So before we lift the stock from wholesale warehouse, we pay the VAT in advance, and then we get a permit, and then we basically carry the stock and we sell it to our consumers. So at one stage, we already paid the VAT. Now, what the notification says, which is impugned, my lord, here, they say that you need to pay an extra additional 6% VAT again on this sale that you have made to the consumers. Now, my lord, the problem here is that for last 3 years, we have been selling our, my lord, this liquor to various consumers without taking any 6% tax from any customers. In fact, the rule also doesn't say, the current rule that has the current rule which is existing, that we need to pay the 6% because, my lord, we lift these items from bonded, we lift these items from wholesale warehouses. Now, this honorable court, in the case which I have just placed before lordship, has intervened to the extent of giving an observation that the authorities will not take any coercive actions against the petitioners when their renewal is in process, my lord. So today also I'm submitting, as our renewal will take place on 15th of February, my lord. So they may not take any coercive actions against us because they will also generate revenue if the licenses are renewed. Until the issue is before your lordship, the issue may be decided accordingly. And thereafter, my lord, if we do not have any case, our cases will be dismissed, my lord. But as on today, since a coordinate bench has given an observation, my lord, that they will not take any coercive actions against the petitioners who are similarly situated like us, my lord. So I'm only humbly submitting that that observation may be given if my learned friend has no difficulties, my lord.
In case of renewal, excise will be 128.
Now, I'm not on the merits, my lord. I'm not arguing the merits because kindly come to the order which I have just submitted, my lord. Kindly come to the order, my lord. Because if I argue on merits, my lord, then there will be difficult because there has to be judicial propriety maintained, my lord. Because the order clearly says that no coercive actions will be taken. Kindly come to the order, my lord.
Yes, I have seen it.
Yes, my lord. May I take your lordship to the paragraph number 12, my lord. The operative part. Meanwhile, till the next returnable date, in pursuance to the impugned notices issued, which are annexed so and so, no coercive action shall be taken. Now, what is this impugned, my lord, thing? Kindly lordship may come to page number, page number, paragraph number 2, my lord, of the order dated 22/01/2026, my lord. The second paragraph, if I may read, my lord. May I read, my lord? That petitioner are 11 numbers of license holders of IMFL on retail shops and are engaged in business of sale of portable liquor, including foreign liquor. Petitioners purchase the IMFL from wholesale warehouses, which are already duty paid by the wholesale warehouses, and subsequently the same are being sold from the retail on shop at a maximum retail price, which is fixed by the state government, and they are prohibiting from collecting VAT separately from the end of consumers, my lord. By issuance of the circular, my lord, Finance Department Taxation Vice Circular, the same which we have challenged in our petition, 14/11/2025, the IMFL of shop retailers have been asked to register themselves as dealers under the Assam Value-Added Tax and also produce no objection certificate, which are used as preconditions for renewal of their licenses of the IMFL on shops. The petitioners are aggrieved that there is no requirement under the statute for payment of VAT by the petitioners at the point of sale from their retail outlets, and therefore in terms of the provisions of Assam VAT Act and the rules itself, they are not required to be registered and do not collect any VAT from consumers, my lord. So in the light of the given facts, my lord, we are also on the similarly placed platform, my lord. So we are at a better place also because, my lord, there was a policy decision of the government to allow us to convert, my lord. So kindly, lordship may come to my writ petition. At page 67, if I may take my lord, page 67. Yes. 67, there is a notification, my lord, gazette, dated 7th April 2025. Which was basically an amendment which was brought into the Assam excise rules. And the relevant part, if I may take your lordship to page 71.
Hmm.
71, my lord. Clause number 13, my lord. Have my lord found? Clause 13. So this is a new amendment which they have brought. In the Principal Act for Rule 279A, the following shall be substituted, namely, subject to the fulfillment of eligibility criteria for grant of IMFL retail off license, the existing IMFL on license in the rural areas, we are in rural areas, my lord, shall have the option to apply for conversion of their existing IMFL on license to IMFL off license on deposit of application fees as prescribed under Rule 113. Such conversion shall be allowed by the district collector with the previous approval of the excise commissioner on deposit of applicable license fees of the IMFL off licenses. Now, these petitioners, my lord, due to this amendment they have brought in, we wanted our license to also to be converted because we don't want to operate as an on license because we have some difficulties which we have filed representation and in pursuant to which government has taken this conscious decision to convert. Now, my lord, after this, we have given our application for conversion at page 73, if I may take your lordship. We have deposited these application fees at page 73. Payment of application fees, 2 lakhs, if my lords have found, by the petitioner. Now, my lord, the whole thing basically revolves around one aspect, my lord. When this conversion is pending, we, through this writ petition, are requesting the authorities to convert our licenses because we cannot operate as on licenses under the locality that we are operating, my lord. And they have taken these fees and they have approved and they have recommended our cases for, my lord, for conversion, my lord. Now, kindly lordship may come to page 74. This is a recommendation given by the district collector for allowing the conversion, if I may take 74, my lord. May I read, my lord? Have my lord found? It is to the Commissioner of Excise regarding application submitted by Srimati Suniti Sonowal, so and so, for conversion of her existing IMFL on license to IMFL off license at her existing license premises located at such and such place, my lord. Now, my lord, may kindly come to the relevant part, the second paragraph. The licensee has already deposited requisite application fees amounting to rupees such and such as laid down under the provisions of Rule 113 of the Assam Excise Rules. The copy of the e-challan is enclosed. The proposal was inquired into through the Inspector of Excise, Tengakhat Excise Circle, and his report in original with all relevant documents, including notarized affidavit cum declaration in conformity with such and such, dated 25/26/2025, submitted by the licensees attached herewith for favor of a kind perusal and necessary action. Last paragraph is very important, my lord. As per the inquiry report submitted by the Inspector of Excise, Tengakhat Circle, the instant proposal submitted for conversion of his existing IMFL on license into off license at her existing license premises may kindly be considered in the interest of government revenue as per Rule 279A, my lord, the rule which I have just read, of the Assam Excise Amendment 2025 as notified by notification to so and so, and hence it is hereby recommended, my lord. So, today, my lord, our grievances is that when we came with this, my lord, when we have approached this authority for convert our license, my lord, to from on to off license, the authority suddenly, without converting, had issued the impugn communication. Now, kindly lordship may come to the impugn communication, my lord, which is at page 77. 77.
Hmm.
My lord, by virtue of this notification of 1411, they are now compelling us to register under Assam AVAT Act regime and basically trying to claim the pending area dues which they say that we have not paid to the authorities, my lord. May I kindly read, my lord? From such and such commissioner and secretary to the government of Assam, finance taxation department to all district commissioner, non-compliance of VAT rules by number of on-shop liquor licenses and so and so. First paragraph is important, my lord. It has been observed that a number of on-shop licenses have not yet complied with the provisions of registration as required under the relevant VAT rules. It is therefore requested that if there is any outstanding VAT or any other government liabilities remaining unpaid, then such licenses may not be renewed. This is very important, my lord. May not be renewed for the next term, my lord. It may also be noted that for renewal of unlicensed liquor, licensee may be asked to submit NOC from jurisdictional tax officer. So, my lord, this document was put to challenge in the writ petition in the order which I have just read, my lord. Here also I have put to challenge the same order. Now, only my lord, humble submission is that as one coordinate bench of this honorable court has given a direction that no coercive actions can be taken or should be taken when the renewal is pending, my lord, on 15th of February onwards. So, my lord, my only humble submission is that today, let there be an observation from this honorable court that, my lord, they may not take any coercive actions against us in the light of the fact that an order has also been passed in the similar facts and circumstances of the case, my lord. Because the last date of filing the application for renewal is given in order 129. My lord, may kindly have a look at the order, my lord. 129. The last date for submitting the renewal application. 129. My lord, B is important for us. It is 1A, my lord. All applications for renewal of retail licenses shall be received in the office of district collector on or before 15th day of February every year, along with all requisite documents as may be determined by the district collector from time to time, but without the license fees payable for renewal of the licenses, my lord. So, on the last occasion, my lord, we have submitted, and the court wanted to have the affidavits from the respondents, and so matter was fixed before 15th of February, my lord. And in the meanwhile, independent, a separate case was filed wherein this court has intervened and have given the observation, my lord. The grounds of challenge are similar, my lord. We have also challenged this on the same grounds, my lord. I will not take trouble your lordship by going into those grounds and other parts, my lord. Only this relevant part I am saying.
Yes.
I'm obliged, my lord.
Lordship, if only peruse rule 128 for a moment, the lordship. The exam exercise rule 128.
Page number?
There is
Rule.
yes, the book 102, the lordship.
10?
102, no, 102, rule number 128. Renewal of license, the lordship.
Yes.
It says that all retail license of foreign liquor, country spirit, and heritage alcoholic beverages and other intoxicants granted under this rule shall be renewed annually by the district collector on payment of prescribed annual license fee if there is nothing adverse to the licensee and if no government dues remain as arrear with the license. Now the issue here is that the VAT Act came in 2015. In 2015, there was specific clause was that under the output of sale output, you have to deposit 6%, which for that they have to get registered under the VAT Act, which from 2015 till date, no one has registered also. They have not registered themselves. And as per the last order, the honorable court has directed them to register themselves under the VAT Act, lordship. Kindly put the last order, lordship. That's specifically given, the petitioner will have to register under the
No.
Yes, your lordship. You register under the VAT Act. Then the last order was complete, was there.
If so advised, court says, my lord. I'll read, my lord. I have the order.
And secondly, here the case of petitioner is that they were first operating as online. After the notification, they submitted application for off license, which till date has not yet been converted or not yet been considered. The TCS forwarded a proposal to the commissioner will take a call, but there's no time limit for it to take the call. Now the issue is that they still are on license. They're still holding an on license shop, your lordship. Till date for that, they have to give that some registration under the VAT Act and pay the requisite VAT fees, not from 2015, from the date from which they are registered as got the license and registered. Because the VAT Act in 2015, from 2015 to 2026, no VAT registration was done, no VAT paid. They paid a VAT at the warehouse, which is collected by the excise department. Now on output sale, that tax is collected by tax department, Lordship. I have given a notification 2015, Your Lordship.
Yes.
Your Lordship. Can you give us a backlog at amendment of section? Good. Amendment of section 10, Your Lordship.
Clause 2, my lord.
Clause 2.
Clause
May I
two.
read, Your Lordship?
Yes.
In the principal act in section 10, subsection 1A, the following shall be substituted, namely, notwithstanding anything contained in this act, the retail on license holder for potable liquor mentioned in the fourth schedule, except country spirit, shall pay output tax on sale made by him at the rate of 6% without any set off of the tax paid on purchases made from bonded warehouse in the state, subject to condition that such potable liquor purchased locally from bonded warehouse of the state. This section, amendment section 10, till date, they have not challenged this section, Your Lordship, stating that this section, this amendment section doesn't apply to us or is illegal or is arbitrary. Since this came in 2015, till date, they are not paying the output tax, they have not registered themselves in the VAT. And here the case is that you are still holding an on license. They are taking a ground that we are applying for an off license. So this section 10, this VAT Act doesn't apply to us. You're still holding an on license. And 296 of the Act, Your Lordship, Assam Excise Rule, may I take, Your Lordship, 296. Page 165, Your Lordship. For a moment, Your Lordship, if a conversion has to be given place, if given petitioner, it amounts to issuing of a new license, Your Lordship. On is a different license, off is a different license. That's a complete new license which will be given to the petitioner. 296 says that license for retail sale of intoxicants shall not be granted. 296C, Your Lordship. Any person who is in arrear in respect of any government revenues or dues or is in default in respect of repayment of any government loan. Since VAT is a government due, Your Lordship. VAT is a government due. They have not paid the VAT. And in that earlier case, which the stay was taken, Your Lordship, no course action will be taken. They have distinguished between the bonded warehouse and the wholesale warehouse. They say we purchase from the wholesale warehouse, not from the bonded warehouse. But here, as per their invoice, they have purchases from the bonded warehouse. The invoice which have they annexed. Page 93, Your Lordship. It says Royal Paradise Bonded Warehouse Private Limited.
At page 94, it is a wholesale warehouse again, my lord. At 94, if your lordship says, we are purchasing from Adri Raj and Company Wholesale Warehouse at page 94.
So even the 93 there, but Paradise Bonded Warehouse.
This is on merit, my learned friend is submitting. My lord, we will obviously they let them file an affidavit in this regard, which the court on the earlier occasion also have directed them. Today, I am not on merit, my lord. This is a crux of the matter which I have submitted, my lord. We are challenging the jurisdiction that you cannot basically issue a notification saying that we are mandated under the VAT Act to be registered, and thereby you can collect or assess tax from us, my lord. If the matter is sub judice before this honorable court has not decided upon it, my lord, my humble submission is that a coordinate bench has passed an order in respect of my lord, my judicial proprietary has to be maintained, my lord. So I'm just making a humble submission, my lord. On merits, my learned friend can file affidavit tomorrow. If they have an urgency, cases can be taken up in next week, my lord, then everything can be decided. Just, my lord, the renewal is coming. I have to submit my renewal application, and the court has observed that, my lord, one thing is that when I renew, they will get the revenue. 3 lakhs they will take from us, plus every recurring revenue they are going to have, it's a win-win situation for both of us, my lord. I'm not saying that any prejudice will cause to them. Let them also understand from the point of view that when the matter is pending before this court, they will earn revenue from me. So I don't think that there will be any prejudice because it will be a continuation of my licenses. So when my license is continued, otherwise my writ petition will become infructuous, my lord. Today, if your lordship doesn't allow me, assuming a hypothetical situation, my lord, tomorrow, my lord, the matter becomes infructuous. My whole purpose of coming before this court will be futile, my lord.
So.
So let them file an
Let
affidavit.
them submit the proposal for renewal, lordship.
Yes.
Let them submit the proposal. I have no, because it's true that from the renewal the state.
We'll earn revenue.
They will earn revenue. But as far as that act is kind of saying that, they might have been.
I'm not saying, my lord, I'm not saying that. My prayer is that no coercive action may be taken in the light of the fact that they may not renew my license. The moment they don't renew my license tomorrow, my lord, then it goes back to the same thing. Neither I have this my lord, the cause of action alive, nor do I have any, my lord, any right alive to ventilate before this honorable court.
Okay, we are not staying the matter, but
Let them submit the proposal for renewal, lordship. We'll consider.
And no coercive action they may take.
till then, no coercive
Yes,
action.
my lord, that is my humble submission.
This is already passed by a coordinate bench of this
Yes, my
court.
lord. I'm highly obliged, my lord.
Mr. Gogoi, you are for? Taxation. Heard, Mr.
H. Buragohai, my lord.
Learned counsel for the petitioner and Mr. R.R. Gogoi, learned standing counsel for the excise department. And Mr. B. Gogoi, learned additional leisure for respondent number. Respondent number 15. Okay. 6 and 7, Mr. Gogoi, and Mr. Hendrik for respondent number 1 and 5. 1 and 5.
I prefer 2, 3, and 4.
2, 3, and 4. But Mr. Gogoi, where is your affidavit?
Lordship, we have received the instruction day before yesterday. We'll file an affidavit within a week time, lordship.
Within?
Within a week time, lordship.
Within a week. Mr. Gogoi, learned standing counsel for the excise department, submits that he has received the instruction and will be filing the counter affidavit within a period of 1 week. Any price for granting 1 week time period is allowed. Mr. Buragohai, learned counsel for the petitioner, has produced 2 orders passed by a coordinate bench of this court dated 22nd January 2026 in WPC number 326 of 2026, and also.
It's the same order. I've just given 2 copies actually, my lord. I'm sorry, my lord.
And submits that the present petitioners are also similarly situated with the petitioners of the writ petition number 326 of 2026, and the coordinate bench of this court, white order dated 22/1/2026, was directed that till returnable debt in persons of the interim notice issued, which are annexed as Annexure B to the writ petition, no coercive action shall be taken. And since the present petitioners are also similarly situated, and since the petitioners have to file their application for renewal of their license, similar order may also be passed in the present petition also, directing the respondent authorities not to take any coercive action against the petitioners. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents that's on record, and also the order dated 22/1/2026 passed in WPC number 326 of 2026. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that till disposal of this petition, till disposal of the present petition, no coercive action shall be taken against the present petitioners.
My lord, the returnable date in the other case was given 4 weeks. So it was operative till returnable date. In
So,
our case,
here it will be till disposal of this.
yes, ma'am, I am highly obliged in that case. Ma'am. Highly obliged. 15 also, my lord, similar orders would follow, my lord, because this is for different district, my lord. Highly obliged. My lord.
Number 16. I need some time to get in my. Oh, they are not right.
None appears for the, you for the respondent.
Not returned.
None appears for the petitioner on call. However, Mr. Upadhyay, learned standing counsel for the respondent authorities submits that he may be granted some time to file.
What a 3 weeks time will be done.
To file affidavit in opposition, they are allowed, rest is always the matter. After 3 weeks.
Obliged.
In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Obliged. Highly obliged. Number 17.
May please, your lordship. In this case, my lord, the petitioner has approached before this honorable court, my lord, due to the non-removal of the electrical wires, my lord, which were passing over the property or houses of the petitioners, my lord. And if the respondent authority has to file affidavit, my lord.
May I please, your lordship?
Hmm.
The lordship instruction are still awaited.
One week or 2 weeks? 2 weeks. 2 weeks. Heard Mr.
W. Rahman.
W. Rahman, learned counsel for the petitioner, and also heard Ms. U. Das, learned standing counsel for the respondent number 1, 2, and 5, and Mr.
C. Paul.
C. Paul, learned counsel for the respondent number
3, 4, and 6.
3, 4, and 6. Ms. Das and Mr. Paul, learned counsel for the respondent authorities price for granting 2 weeks time to file counter affidavit. They are allowed, rest is list the matter. List the matter after 2 weeks.
Number 18.
May plead your lordship. Kindly pass over the matter for the day. My senior is unwell.
Where is your senior?
Civil forces after 2 weeks, my lord, I prefer some time to have the inspection. They have sought for 2 weeks time to place the terrorist.
Notice has been issued here.
Notice issued, but.
Okay. Heard Miss, your name?
R. Begum.
R. Begum, learned counsel for the petitioner. And Mr. Gogoi for the respondent number
For the service vision.
for SSA. For SSA being the respondent number.
Two respondents, two.
Respondent number 2. And for rest of the respondent, none appears. Education department. None appears for the rest of the respondent. Mr. Gogoi submits that he may be granted 2 weeks time.
Yes, sir.
To file his affidavit in opposition. They are allowed. SSL is the matter after 2 weeks.
Item 19.
Appearing for number 2 and 3, lordship. Operating has sought more time to file our affidavit, lordship. Section 7. Otherwise, yes, but number 4 has filed their affidavit in opposition.
You offer respondent number 2 and
3.
2 and 3. 2 and 3. Heard Mr. Islam, learned counsel for the petitioner, and also heard Mr. Your name, please? Pardon?
S.R. Borwa.
S.R. Borwa, learned standing counsel for the respondent number 2 and 3, and you?
Sir, I'm Islam.
Learned counsel for the respondent number 4. Respondent number 4. Mr. Borwa submits that respondent number 4 has already filed counter affidavit and he may be granted 2 weeks time to file counter affidavit in this matter. They are allowed, rest is the matter after 2 weeks.
2 weeks.
Lord,
Earlier interim order may fairly continue.
Interim order pass earlier shall continue.
Number 20.
May I please, your lordship? Lord, this is also a matter relates to eviction, my lord. On the last occasion, my respected friend on the other side, my lord, they submitted that instruction is awaited, my lord. And my lord, in the meantime, they have received instructions, but the affidavit was required to be filed, but my lord, we have not received any affidavit till date, my lord. And in the meantime, my lord, we have also filed an additional affidavit yesterday, my lord, which perhaps is not on record. And my lord, in addition to that, my lord, we are receiving, my lord, documents after filing of this petition, my lord. An order, my lord, had been passed by this honorable court long back, my lord, in the year 2001, my lord, directing the, my lord, revenue authorities to demarcate the area. And that exercise, my lord, they have though initiated, but it has not been, my lord, finalized or culminated to any logical conclusion, my lord. So those things, my lord, will help in our case also, my lord, for proper adjudication in the interest of justice, my lord. We would also like to bring those on record, my lord, if my lordship permits us, my lord. My lord, 3 weeks time may further be given, my lord, to organize all these things, my lord. And in the meantime, my lord, if the state file affidavit, my lord, that we will also respond to that also, my lord.
Yes, Mr. Borua?
Yes, lordship, actually, this matter is dealt by Mr. Adam Goswami, lordship. Otherwise, they are protected by the interim order, lordship. And the additional affidavit they have filed, that is not also with me, lordship. So can it be after 3 weeks, lordship? In the meantime, the state transporters will file our affidavit.
Okay. Heard Mr. A.R. Bhuya, learned counsel for the petitioner, Mr. Borua for the respondent number.
My lord, for the revenue, my lord.
Number 2345.
2345 and Mr. Bhattacharya for respondent number 1. Respondent number 1. Mr. Borua submits that he may be granted 3 weeks time to file the counter affidavit in this matter. Mr. Bhuya, learned counsel for the petitioner, submits that the petitioner has already filed one additional affidavit and but the same has not been placed on record. And further, Mr. Bhuya submits that the petitioner may also be permitted to file another additional affidavit bringing on record some of the orders passed by this court in the year
2001, my lord.
2001 in
My lord, in WPC, my lord.
In WPC number
8433 of 2001, my lord.
8433,
my lord.
8433 of 2001.
2001, my lord.
2001.
Manikuddin versus State of Assam, my lord.
Within Manikuddin versus State of Assam.
my lord.
State of Assam. We are allowed to recess the matter after 3 weeks. Taking the additional affidavit filed by the petitioner with the record. And Mr. Bhuya is also permitted to file additional affidavit to bring on record the orders passed by this court in WPC number so and so. List after 3 weeks.
My lord, interim order is there. my lord.
Interim order passerly shall continue.
My lord. Highly obliged, my lord.
Number 39.
Please, Your Honor. Your Honor, in this matter, on the 18th of December, an order was passed where certain clarifications were sought from the respondents. So accordingly, they served on me an affidavit, an additional affidavit. I have also given my response to that affidavit. So all pleadings are complete. This matter is ripe, Your Honor. So we can start actually.
In this matter, also additional probation and Mr. P. Nayak will appear. Yes. Today he has some difficulty, lordship. So I pay for giving another day in the matter also.
Very well. Your Honor may consider the 24th. A short date may be given because there's a lot of money to the fair price shop dealers that's in this at stake here.
On
24th, Your Honor.
February.
Yes.
Okay. Heard Mr. Didas, learned counsel for the petitioner. Then Mr. Borua for Mr. Borua for the respondent authorities. Mr. Borua submits that Mr. P. Nayak, learned additional AG, will appear in this matter and he has some difficulties today. And as such, Mr. Borua prays for listening the matter after on 24th of February. Where allowed, races will list the matter on 24th February.
Deeply obliged.
41.
Lordship, for item 41, I request to take the matter for time being as my senior is on another court.
Lordship, otherwise, Lordship, although notice was issued in the matter, but they have not served us the extra copy, Lordship. So let them first serve the extra copy. Matter will be come after
Furnish a copy to him today. We will list the matter after 2 weeks.
three extra copies, Lordship.
3 extra copies.
Yes, Lordship.
You have the copy with you? No. Who is your senior?
MS Loskar.
Lordship, I kindly reflect in the order, Lordship. Accordingly, tables are asked.
Okay.
Within
Okay.
3 days, Lordship.
Heard, miss, your name please?
S. Ahmed.
S. Ahmed, learned counsel appearing on behalf of Mr. M.S. Laskar.
Yes.
Learned counsel for the petitioner and Mr. Borua for the respondent authorities. Mr. Borua submits that in this matter, though notice was issued by order dated 10/11/2025, yet extra requisite copy of the petition has not been furnished to him. And as such, he tries for issuing direction to the petitioner to furnish 3 extra requisite copy of the petition to him. Where allowed, the petitioner shall furnish 3 extra copies of the writ petition to Mr. Borua within a period of 2 days from today,
Lordship.
2 working days from today. You inform Mr. Laskar. After 3 weeks?
After 4 weeks, Lordship.
4 weeks. After 4 weeks.
42.
Much obliged.
May I please? May I please, Your Lordship? In this case, my lord, the petitioner's vehicle was hired by the respondent authority, my lord, by the Commissioner of Police, my lord, on but hire search bill amount has not been paid to the petitioner, my lord, till date, my lord, which was released on 10/6/2023, my lord, for about 3 years, my lord. The vehicle was used by the respondent authority, my lord.
This is a small amount. You may make payment of the amount.
Verification is to be done, madam, because no admission by the madam competent authority, madam. So we have to verify the madam service. He's claiming that it is of 2023, madam. We have to verify, madam. Then only we can pay, madam.
But for verification, how much time you will take?
No admission again, madam. If it is not admitted by the competent authority, madam, only excited by your lordship. So I have to take, madam.
My lord, then my lord, define time frame may be given, my lord, within the specific time, my lord. The verification is to be done, my lord, and then if
Madam, again, 2 weeks time may be granted, madam. I'll take instruction. Because that will be, madam, because
No, madam, you see,
madam,
the vehicle was hired by the police commissioner of Guwahati, police commissionerate of Guwahati. To obtain instruction from police commissionerate of Guwahati, why do you want 2 weeks time?
my lordship will see, madam, this page of thing, madam. Date of hiring is 20. So, madam, he has
Yes.
filed it after 5 years, madam.
Mm.
The last part of, madam, 25. So, madam, it's a own bill. We have to verify, madam.
Full bill, that's all right. You have
My lord.
failed to clear the bills, therefore he approached this court.
My lord,
Hmm?
my lord, as per, by the contents of this court, my lord has already, my lord, observed that if it is not admitted by the competent authority, my lord,
No, no.
it cannot be.
We,
There is no event, there is no seal and sign of the, my lord, authority, my lord, when there's a, or case for this. So this seal is there, that, my lord, whether he has received it or, my lord, that, my lord, you have to verify it, my lord. 2 weeks time is necessary.
Seal and sign is
this
there.
page number 14 of the writ petition that
Seal and sign is
MT
there.
motor transport officer.
He is, my lord, there, but where is the signature, my lord, that they have received it?
You see page number 14?
Yes, my lord, there is no signature here, my lord. Signature, no here, signature, I haven't seen signature, put signature.
Signature of the user with destination or designation. That is there.
Destination.
Designation.
The signatures, my lord, I will, my lord, these things are to be verified, my lord, because, without
No,
verification.
that's all right. First, they will obtain instruction whether the vehicle was used by the commissionerate or not. We'll take it up on Wednesday. We'll not grant you 2 weeks time.
Yes, my lord.
For a small amount, you have compelled them to file this writ petition.
Yes, my lord. Then on-
Heard, Mr.
W. Rahman.
Learned counsel for the petitioner and Miss Udas. Learned. Additional lady.
Additional senior government.
Any additional senior government advocate for the respondent authorities. Though though Miss Das prayed for granting her 3 weeks time to file counter affidavit, yet in view of the given facts and circumstances on the record, Ms. Das is granted 2 days time to obtain verbal instruction from the respondent authorities regarding use of the petitioner vehicle by the respondent authorities. List the matter on Wednesday.
My lord.
I have some problem, my lord. Wednesday, 10, my lord. 10 to, my lord.
10 to.
10 to.
And,
More.
this will be very good. My lord, that is on Thursday, then, if you have problem with
Then Friday, my lord.
Friday.
Then Friday.
Okay, Friday.
On 13th February,
30th. Okay, my lord.
and then 43.
Obviously.
Non-payment of admitted liability, my lord.
Awaiting instruction about construction still awaited. Then there is some admission from the record lodge.
Hmm. Heard, Mr.
HK Sharma.
Learned counsel for the petitioner and Mr. Gogoi for the respondent authorities. Mr. Gogoi submits that instructions are still awaited. Accordingly, it is provided that SSL lays the matter after 2 weeks. In the meantime, Mr. Gogoi shall receive instruction and apprise this court on next step.
Obliged.
Item 21 for orders.
Okay. This one. 2 p.m. then. At 2 p.m.
Lordship, may I pay, Lordship, for item number 16, Lordship, I'm sorry I couldn't be here, Lordship, can my name be recorded? I just made
Later on, Miss,
item number 16, Lordship.
your name,
Nanda.
you Nanda, entered appearance.
Right, Lordship.
Learned counsel for the petition. Is the Islam after at 2 o'clock?
Lordship, item number 26 is written for order by the I filed the counsel into the review petition, which is not taken to record. It will be time with.
When?
Because it is not in record for that.
No, that's all right. When do you want?
Twelve or 13 February.
12 or 13 February.
Lordship, in this matter, we got counter affidavit before 2 days ago. We need some time to go through this counter affidavit. Lordship, it may be listed again on after 4 weeks.
What is too long? Because it is the actually review of the supplementary law. I have taken all the grounds, my lord, and then I am relying on the decision of the honorable court and the Supreme Court. Why this review is not maintained? So this is a simple thing, my lord. I will earlier also the honorable court dismissed this review petition on that ground also.
17th of February.
17th February. Any inconvenience on that day? 17th February? Okay. Third Miss
M. Kolita.
Learned Counsel for the appellant or
I'm for the review petitioner, my lord.
Learned Counsel for the petitioner and Miss U. Chakraborty, Learned Senior Standing Counsel for the respondent number 1.
1 and 2. Both.
1 and 2.
Yes.
1 and 2. Ms. Chakraborty submits that she has filed counter affidavit in this matter, but the same has not been placed on record. You have received a copy.
Yes, Lordship.
The Learned Counsel for the review petitioner submits that she has received the copy and she needs 2 weeks time to file reply to the counter affidavit. Fair allowed, recess shall list the matter on 17th
Of February.
17th of February.
Okay, Lordship.
Okay. We'll resume it to.
Why let me take it up after some time, madam, he's coming, our book on the last day, madam, directed our book instruction matter, he's on the way, madam, after some time.
22. Item 22. 22.
Same.
23.
You for the
For respondent number 3,
respondent number 3.
kindly so the documentation may be made, your lordship, for we have to file that for affidavit for filing the affidavit, kindly sort of.
None appears for the petitioner on call. How about Mr.? Your name, please? Pardon?
For respondent number 3,
Your name?
P. Bhaumik.
P. Bhaumik, Learned Counsel for the contender number 3. Present, and he press for granting
3 weeks time, number 3.
3 weeks time to file the affidavit. Where allowed, recess unless the matter after 3 weeks.
I am for the petitioner here, my lord. Item 23, my lord.
Later on,
Here,
Mr.
Connector meter is listed on 9th of February, my lord.
Your
The
name,
division-
please?
A Boro, my lord.
A?
A Boro.
A Boro, entered appearance and submits that connected matter is listed on
9th
9th of February.
9th February. Contempt number 693/22.
Being contempt petition number
693/22.
693 of
22.
2022. And he press for list this matter along with the aforementioned contempt petition. Where allowed, recess shall list the matter on
9.
that to follow.
9.
But lordship would some time to file the affidavit in this matter.
Whether you have filed affidavit in that matter?
সেইদিনা ফাইল কৰিলো মই তাৰ পৰা আছে লিষ্ট চিমিলাৰ দুটা
নহয় দুইত আছে
চিমিলাৰ দুটা আছে
নহয় আমাৰ 2 weeks টাইম লাগিব এটা ফাইল কৰিবলৈ
কোথায় লবি
এতিয়া কিমান টাইম লাগিব
অনলাইন মানে
on that day will take the paper
অবলাইজ
24. My lord, order complied, my lord. Quantum may be closed.
Order having complied with. Heard Mr. Sohan, learned counsel for the petitioner, and Mr. Gogoi for the contender. Mr. Sohan submits that the order has been complied with and this matter may be closed. Mr. Gogoi, learned counsel for the contender, also submits that the order has been complied with and the matter may be closed. Accordingly, taking note of the submission of learned counsel for both the parties, this matter stands closed.
25.
Kindly see the order dated 12/12/2005 Lordship.
Who is for the respondent?
Chief Engineer
P.K. Das.
I vote Thakur আছে last.
I. Thakur.
I vote Thakur. I vote Thakur. Last time we appeared.
12-12.
12.
12-12-1. P.K. Das appeared for the chief engineer.
P.K. Das.
Pallab Kumar Das.
Chief Engineer for video conference.
Okay, he is the chief engineer.
Chief Engineer. And he submitted that the Lordship, the entire procedure will be completed in the month of January 2026.
I. Thakur will call. Wait for some time. He will call the council.
Numbers 29 and 30.
None appears for the petitioner on call. This shall release the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. In 29 and 30.
31.
None appears for the petitioner on call.
My lord, council is in legs. I'll call this for the matter may kindly be passed over.
Item number?
31 and 32.
Okay.
I'll call him. He's just outside.
Okay.
31 and 32.
31.
Okay.
Legs like a more just about
Okay.
with us. Yes.
Item 34.
May I please, the Lordship. Lordship, in this case, Lordship, a notice was duly served. ID card has been returned. And Lordship, if ID card is reflected, Lordship, on 22/12/2025, the notice was received, Lordship. And ultimately, Lordship, I have already communicated with the advocate of the Forest Department, Lordship. But no one given response, Lordship. Here in this case, Lordship, this court has been given directions to release my vehicle. And this order has been given 26/9/2025, Lordship. But till date, Lordship, my vehicle has not been released without showing any reasons. Lordship, in order, Lordship, page 12, keep 9.
operative part is 12, Lordship. Here in this case, Lordship, 8 years back, my vehicle has been seized. Ultimately, all the proceeding has been concluded, and this honorable court has directed to release my vehicle, Lordship, immediately. And that order has been 26/9.
Okay, Forest Department, council. Forest Department of Onet. Google. But I've seen that I have noticed the service. But for some time, he will inform the forest council for the forest department. Next.
Item 25.
May I please, Your Lordship?
Mm.
Lordship, the service is complete and the pleadings are also complete, Lordship. The matter may be fixed for admission hearing next week, Lordship.
Can it be on 13th, Your Lordship? I'm appearing on respondent number 2, Your Lordship.
Respondent number 2. Heard Miss
M. Das, Lordship, on behalf of
M.
P.
Das, learned counsel appearing on behalf of Mr.
P. Mohanta, Lordship.
P. Monta, learned counsel for the petitioner. And Mr. Biswas for respondent number?
Respondent number 2.
Respondent number 2. The learned counsel for the petitioner submits that here, in this matter, the pleadings have already been completed. And
Pleadings is also complete.
Pleadings completed, Lordship.
Pleadings
Pleadings
are-
completed.
affidavits have been exchanged.
yes, pleadings have been completed and affidavit have already been exchanged. And as such, the matter may be listed for admission hearing. Accordingly, it is provided that this shall list the matter for admission hearing on
13th, Your Lordship.
13th.
Value of the
36.
Respondent number 3 কোনো appear করিব মানে office note indicates that respondent number 3 while the notice was issued, I think that was skipped, and therefore office note has indicated that neither notice was issued nor the respondent number 3 was waived, and therefore placed before your lordship.
Respondent number 3 has been possibly not correctly made particular. The respondent number 3 has to be properly, they have to incorporate properly. They have said first appellate authority, office of the district commissioner, who then public distribution.
Page 19, my lord, page 19, I have submitted an application.
No, Mr. Sharma, you see, no notice was issued to the respondent number 3.
Yes, my lord. Office note indicated, man, like that. If my friend appears, my lord, then notice will complete, my lord.
But is it the proper authority to implement in this petition?
My lord, first appellate authority, I have submitted application under RTI. Then it was forwarded, and ultimately the final authority of State Information Commission had directed the Food and Civil Supplies Department to furnish the information, which has not been given to me.
Whether you have correctly mentioned the departments, food, public distribution and consumer affairs.
Well, in the office of the Deputy Commissioner, there are some certain department, Food and Civil Supply Wing, then under the office of the Deputy Commissioner.
Mr. Das, Mr. Nath, who is the proper authority?
So maybe going by the, but come deputy commissioner, ultimately this is the first appellate authority.
This is the first, yes.
This is the first appellate authority. So he, at least he can correct it, like first appellate authority, like that, he can take.
Okay.
Then for this.
He can appear, my lord, ultimately deputy commissioner.
No, maybe you have to correctly mention it.
He has to make it correct and but what I have seen, he has come for implementation of the order. Order is 9,
Yes.
order is 9/1/2025.
Page 16.
Kindly see the direction.
Page number?
Page 60, additional affidavit.
Politic portion is page 61, last paragraph. This is the direction by the State Information Commission. Accordingly, the commission directs, accordingly, the commission directs the SPIO and the Deputy Director Food Public Distribution and Consumer Affairs Sulaga to furnish an appropriate reply to the petitioner in conformance with the provisions of RTI Act of 2005 within a period of 20 days from the date of receipt of this order.
4 and 5, respondent number 4 and 5.
This operated 4 and 5. So they are the main respondents.
That's not all of deputy commissioner. Deputy.
4 and 5.
Yes.
4 and 5.
And therefore no notice was issued, probably on a first day.
Okay. But the question is whether this respondent number 3 is a necessary party here or not.
At this stage, I think since direction is issued to the SPIO 4 and 5. So at this stage, not necessary, my lord. If required, I'll implement, my lord. Implement, my lord. At this stage, not required. If 4 and 5 has filed affidavit stating that they are ready to put. Affidavit has not been filed by the respondent number 4 and 5, and direction was issued by the State Commission to the respondent number 4 and 5.
4 and 5, who is for 4 and 5?
State Public Information Officer.
They are in fact the government officials only. Lordship may grant us some time out from 4 and 5. We have to take instructions on what action they have taken after the order.
4 and 5.
For 4 and 5 now.
Mr. N. Sharma, learned counsel for the petitioner, Mr. D. Nath, learned senior government advocate for the respondent number 1 and 4.
1, 1, 4, what are they pairing?
1, 4, 5.
4, 5 I am pairing. 1, 4 and 5 I am.
1, 4 and 5. And Miss MD Bora for respondent number
6 and 7, my lord.
6 and 7. Mr. Roy, you are here? Okay, okay. Okay. Mr. D. Nath, learned additional, learned senior government advocate submits that he may be granted some time to obtain instruction in respect of respondent number 4 and 5. We are allowed recessal less the matter after 1 week?
Lordship, 2 weeks time, Lord.
2 weeks.
Lordship.
2 weeks.
Yes.
We are allowed recessal less the matter after 2 weeks.
Regarding respondent number 3, at this stage, my lord, I will not press any, my lord, against respondent number 3. Because 3 and 4 almost same person.
No, but no notice has been issued to the respondent
Yes,
number
correct.
3.
And therefore no notice has been issued.
Mr. Sharma also submits that he will not pursue the matter against the respondent number 3 at this stage.
Yes. No, the heading.
May I please have lordship? Lordship, kindly pay order dated 7/11/25, lordship. Thereafter, after serving notice, this letter was issued to us, lordship.
কি লেটাৰ এইটো কেতিয়া লেটাৰ এইটো কোনে ক'লে? No, 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 no. এখন আমাক কেতিয়া দিবা আমাক দিবা তেতিয়াহ'লে আমি নাজানো কপি এটা কপি কপি কৰি ৰাখিব লাগে এইখন আগতে দিছোৱে নহয় আমি আকৌ এইখন কি দিছে এইখন আগত দিব তাৰপিছত দিছোৱে আমি এইখন
Mr. Nath, you received a copy of this letter?
But that letter I have asked my friend to take off.
I will get.
Because I have communicated with the deputy commissioner. He said that we have already sent it to the tribal affairs department. So all the statements, hearing and everything, Gaura's certificate, everything, we have sent it to the department. After that, we have not received anything. I will take the instruction. I will take a copy from him. What
No, as per the office memorandum, the deputy commissioner is the district commissioner is the appropriate authority to issue such certificate.
That you will do. Okay. Otherwise, my instruction on 24/7/25, a letter has been sent to the authority to the department. That instruction I have placed, Lordship has recorded that. It is
No, that's all right, but this letter of the joint secretary to the Gupta Assam indicates that district commissioner is the appropriate authority.
That Malad I should take a copy and accordingly it will be put up.
Heard, Mr. H. Das, learned counsel for the petitioner, and Mr. D. Nath, learned counsel for the contender. During the course of hearing, Mr. Das has produced one letter received by him from the Joint Secretary to the Gupta Assam Department of Social Justice and Empowerment, dated 31st of December 2025. And on the basis of the said letter, Mr. Das submits that the petitioner has been advised to approach the concerned district commissioner for redressal of the matter in accordance with the provision of Office Memorandum number TAD/BC/321/2022/20, dated 8/8/2022, which prescribes the authority, procedure, and guidelines for issuance of caste certificate. Mr. Nath submits that he has not received the aforesaid copy of the letter. However, Mr. Das undertakes to furnish a copy of the same to Mr. Nath, learned counsel for the contender. Accordingly, it is provided that Mr. Nath shall obtain instruction and apprise his court on next date. List the matter on after 1 week.
Wow.
Okay.
Lordship, kindly keep it on 16th or 17th. I'll
16.
Huh?
16.
16.
16.
The copy of it is you furnish a copy to the court.
About 5 to 8 ago, so I finished the copy.
And also furnish a copy to him.
Okay, no, sir.
A copy of the letter dated 31/12/2025 produced before this court shall be take to the record.
Storage.
Standing 32.
In item number 32.
My lord, I am the petitioner.
I have entered appearance. It is, this case is going on. I have gone through the records. But I got the record yesterday. I took for 2 weeks time.
My lord, for last 1 year, these two gentlemen, every day, they are violating court order. Just give me 2 minutes, I'll demonstrate. Personal appearance was given. They came and made a submission that we have filed a writ appeal. And wonderfully, that writ appeal was withdrawn. Having realized that there is hardly any merit in that appeal, they withdrawn the writ appeal. Now, my lord, after an order of personal appearance was granted, one gentleman appeared. My lord will just see how the executive are treating orders of this court. The order here was passed way back in February 2025. Their sitting idle, at least 5-6 dates were taken. The court came down very heavily on the contemner. Just see 2 or 3 orders passed by this honorable court, the last order and the order before that order.
I have seen, I have seen. It's a serious matter, otherwise I have seen. Order is very clear. And the actions are not taken in the right way. Kindly give me 2 weeks time. Let me come back. I have got the file yesterday. But they have entered me. I'm entering for the first time today. File has been handed over to me yesterday. Possibly my friend knows I'm appearing for the first time here.
That is true, because I have got nothing against councils, my lord, council, because the contemners are every day they are coming up with new ploys. Change council, file a appeal, withdraw it, we will file affidavit, we will file. Twice they gave a commitment to this court that they are complying it. It is not a question of 2 weeks, my lord, with folded hands. Had it been 2 weeks from February, I would have smilingly, I would have agreed. For 2 months, I would have agreed. I have waited for 1 year. Despite me coming to this court, getting an order in my favor, which has attained finality unchallenged, 305-day delay, they have filed an appeal. Having realized the merit of the appeal, they withdraw. And one day they made a submission. My lord,
Mr. Vishwas, sir, not appeared for the first time today.
Sir, my lord, with all, I understand, my lord.
I go through the papers.
Then next week, my lord, because 2 weeks is a very long time, my lord, considering the fact that from February, this matter is lingering. Last February 25, this matter is lingering.
No, I have no problem in granting 1 week time, but the question is whether he will be able to
Now, my lord,
obtain instruction and go through the papers.
his clients are senior officers of the rank of director of the rank of director, and I hope that they will be able to assist the council within a 7 days time. It is not, my lord, that much complicated. No astrophysics is involved here, my lord. It's a simple tender matter. They cancel the tender. The High Court said cancellation is bad. You go in accordance with the tender terms. They again revisited the technical, just to somehow, I mean, take me out of the equation. Take the petitioner out of the equation. They are doing, this is an ego clash. Essentially, this is an ego clash. There cannot be any legal logic behind it.
Okay, let Mr. Nath obtain an instruction and
Humbly request for that, but I'll definitely suggest my client to go by the records, and absolutely by the records only. If something has happened as has been submitted by learned friend, I'll definitely not suggest them to do that. Definitely, there is no scope for circumventing the High Court order.
okay, Mr. Nath, I'm granting you 1 week time.
Kindly
1 week time.
Today is Friday. Can you give me 10 days time? Let me come back, because I have to affidavit has been filed. I have seen affidavit has been filed. I have been filed. Lot of developments are there. Orders are there. I have to suggest them and get it done, because these are departmental things. Lordship may appreciate. Lord. It is no dispute. Order was passed in 4/2/2025, and 1 year left. I do admit, but ultimately, my lord, I entered the in the matter today. Can you give us? I have prayed for 2 weeks time, my lord, and it's a tender matter. Not giving award or not taking the item is a loss to the government also.
Only
Petitioner's interest is business interest. Our interest is also there.
Okay, then let it be on 28th of February.
No, my lord, can it be, because even if 10 days time, can it be on 17th of February, my lord, with folded hands, my lord, because even then 17th, 10 days is.
On 18th.
Okay, 18, 1 day.
Okay, 18th.
No, 18 mag bag. Okay. 19 तारीख लो.
Heard Mr. Ambitious, Learned Counsel for the petitioner, Mr. D. Nath, Learned Counsel for the contenders. Mr. Nath submits that he has received the papers yesterday and he is appearing before the court for the first time. And he pressed for granting him 10 days time. The bear is accordingly allowed to raise the matter on 18th.
Malad 20, both of us have agreed 20.
20, okay, 20.
He has got sufficient time.
Yes,
Okay.
I signed it sometime. Okay, yes, okay.
I hope the good sense prevail. Even the court also last time told when they came in person that the court said them that I hope the good sense prevails, otherwise you'll face the con. The court said in the presence of the director.
Whatever is going to happen, it will be happen before the honorable court. And to the best of our ability, we can suggest only.
Okay.
Court is there, honorable.
I'm
Ultimately, we have to come up before the honorable court only.
come up with clean. I'm the-
I'm extremely sorry, my lord. Sorry to interruption. In item number 29 and 30, my lord, I could not, I was on lag, my lord. So I could not.
Give your name to the court master.
Oblige. A date may be given, my lord.
Date already given perhaps. Date to the
Oblige.
Islam.
21, my lord, on the last session, Lord, it has requested me, my lord, to take the instructions from the finance department. My lord, I have received the instructions. My lord, this proposal was found to be incomplete in some aspects, and hence that proposal has been returned, my lord. Please to these instructions will be kept as a part of the record, my lord.
You are for the petitioner?
Lordship, Lordship, I am appear on behalf of R. Islam. Lordship is just.
Okay.
Because, my lord, the three things have been found to have their shortfall. My lord, the second page is lordship says, my lord, the effective date of provincialization, then, my lord, approval from the honorable chief minister, and then a copy of the, my lord, SLC meeting and total financial implication. These things, once these things are provided by the education department, then we may be able to take a call, my lord. If we humble some at this stage, my lord.
So, madam, you see, your proposal is incomplete.
But I will share this instruction right now with my colleague in WhatsApp. Lord, say, will you please to fix a date, my lord? Give me her some time, my lord. She will come up with the updated instructions, my lord.
Mr. Hawk, Learned Counsel, appeared on behalf of Mr. R. Islam,
Yes.
Learned Conducting Counsel for the petitioner. Mr. Borpuzari for the Finance Department and Ms. Supriya for the contender. Person to the order dated 2nd of February 2026, Mr. Borpuzari has obtained instruction from the Finance Department and placed a copy of the same before this court dated 5/2/2026. And he submits that, and on the basis of the said instruction, he submits that the Finance Department has returned the file.
My lord. To the
being e-file number 295395 to the Department of School Education, Utenberget Elementary, with a request to furnish effective date of provincialization of the incumbent, along with the approval of Honorable Chief Minister Assam comma, a copy of the SLSC minutes dated 38/5/2023 and a copy of writ petition being WPC numbers 6697 of 2021 and total financial implication. And Mr. Borpuzari further submits that he will share a copy of the aforementioned instruction with the learned counsel for the contemptor, and some time may be given to the learned counsel for the contemptor to obtain up-to-date instruction. Accordingly, taking note of the submission of Mr. Borpuzari, it is provided that Ms. Sutia shall obtain up-to-date instruction from the from the contemptor and apprise this court on sorry, 18th. The letter produced, the instruction produced before the court today by Mr. Borpuzari shall be marked as annexure B and be tagged with the report.
3 weeks, my lord, because
After
3 weeks, my lord.
3 weeks. 2nd March. And March. 2nd March.
2nd of March, my
Well, I have already shared my.
okay, all right.
And so,
Coming item 22.
22.
And in this case, I have received instruction, madam. Madam, may period next page, madam, therefore. Court has already been created, madam, in the name of the petitioner, madam, and it has been sent to the higher authority for, madam, necessary process, madam.
Heard Mr. Hawk, learned counsel appearing on behalf of Mr. R. Islam, learned
Swear
conducting counsel for the petitioner, and also heard Ms. Sophia, learned counsel for the contemptor. During the course of deliberation, Ms. Sophia has produced one letter
8, no? 5,
of the director in charge, Directorate of Elementary Education, Assam, dated 5th of February 2026, and on the basis of the aforementioned letters, he submits that the director has already requested the government for creation of one post of tutor for provincialization of service in respect of the petitioner Nur Mustafa Jamal in WPC number 1606 of 2020 against Borongabari ME School under Dorong District for compliance of the order of this court dated 12/1/2014 in WPC number 4326 of 2023. Under the provision of provincialization of services as per Act of 2017. So when the process will be completed?
Madam, though it has sent yesterday, madam, matter may take after 3 weeks, madam.
After 3 weeks. Ms. Sutia also submits that this matter may be posted after 3 weeks so as to enable her to obtain up-to-date instruction in respect of the proposal already sent for creation of post of tutor in favor of the petitioner, in respect of the petitioner. We are allowed recess the matter on 2nd of March. The letter produced before the court today shall be marked as Annexure B and be taken to the record.
Highly obliged. Okay.
In this matter, we need some more time because I just been got informed that the executive engineer has sent the fund demand proposal to chief engineer and chief engineer has just forwarded to the secretary, your lordship. So thereafter, this process will go on to the finance division department. So some time may be given to us, your lordship, to take the updated instruction.
No, Mr. Gogoi, you see, the chief engineer has appeared before this court.
Yes, your lordship.
And assured that the process will be completed by the month of January 2026.
Yes, your lordship. That
Today, we
proposal
are
has
in
been,
the month
sent
of
to the-
February.
Yes, the proposal has been sent in the month of January only, your lordship, the secretary, your lordship. So if I may, some 2 weeks time, your lordship, because what happened is that the ended amount is 7 lakhs and earlier 2 lakhs was given forwarded to the higher authority. Now again, different proposal 5 lakhs has been forwarded to the authority, your lordship.
Okay. Heard Mr. MZ Shah, learned counsel for the petitioner, and Mr. Gogoi for the contender. Mr. Gogoi prays for granting 2 weeks time to comply with the order of this court. They are allowed, recess and leaves the matter on.
25th.
25th. Let it be on 2nd of March,
Very well, lordship.
on which Mr. Gogoi shall produce the compliance order before this court.
Okay.
You produce the compliance order on that day.
Okay.
Item 34, tell me.
In this matter, maybe grant some time because our name is not shown in the lordship.
Your Honor, lordship, he is not appeared, so that's why name is not shown.
None of the name is shown. কার নাম দেখুন। কার নাম
No, no, contempt case appear হওয়া নাই। ওকলাত নামে ফাইল করা নাই।
আমাকে মনে হয় 30 করো।
এখানে আছে।
Yes, there's a contempt petition is against the divisional forest officer.
Yes, lordship.
Kasar.
Kasar.
So notice has been served.
Sir.
Therefore, you have been called.
Yes, sir, lordship. So may I play a copy of the contempt petition? I'll take the instruction, lordship, in this matter.
Okay. Heard Mr. I Hawk, learned counsel for the petitioner. And also heard Mr. Gogoi, learned standing counsel for the forest department. Forest department. Office note dated 3/2/2026 indicates that AD card has been received from the sole respondent. And it appears that the notice deemed to have been served upon the sole respondent. Upon the contender, Mr. Gogoi submits that he may be furnished with a copy of this present petition and may be granted 2 weeks time to obtain instruction. They are allowed, recess or less the matter after 2 weeks. On
27.
27th.
Lordship, our name will be reflected in the causes, the lordship.
Recess shall also reflect the name of Mr. Gogoi in the cause list.
Lordship. Lordship is doing, here my vehicle has been seized 8 years back, lordship. So if possible, lordship, 1 week may be given, lordship.
We'll take the instruction from Kasar.
Lordship,
So that's why I'm paying for it.
Otherwise, lordship, my vehicle is going to damage.
Maybe, but when did you file the writ petition here?
Lordship, all the proceeding has been completed in the year 2023. And ultimately, lordship, 24.
Then?
Lordship, this petition is, and.
Okay, 10 days time.
20.
20.
Obliged, lordship.
Highly obliged.